Okay. Well, I was just streaming some video to fill in the time while we wait for the court to come back in session, and the session ended abruptly. Not sure exactly what's going on, so I've restarted. We've got a half an hour to go until they're supposed to be back. Um, I guess we'll do our usual update of see if there's anything new with um, the local cases that I've been covering. James Brenner, we learned yesterday, his hearing on the 31st has been postponed to August 14th. And so let's see. Corey Richens. Last we knew, she had rehearings, and it looks like it's still that way, and it's all to do with the civil cases. Uh, we've got first one is Alec Wright versus Corey Richens, and we've got and that one is says pre WebEx prejudgment writ hearing, and that one is on the 17th. On the 25th, we've got another WebEx, which is a motion to stay in that same case. And then on August 3rd, we have Corey Richens versus Katie Richens Benson. Katie is Eric Richens' sister and the trustee, and she's suing for $2 million for, I think that's supposed to be the value of Eric's house in the Camas area. He bought that prior to their marriage, and she's suing for it, saying that she contributed to the payments and so forth. But that doesn't seem to wash with what we've heard, and she was stealing left and right from him. There is another suit which, after she filed the $2 million lawsuit against the estate filed a $13 million lawsuit. So let's see if we can find something on the $13 million lawsuit to find out the particulars. I think it's probably a wrongful death. Let's see. Well, part of it seems to be for the proceeds from her children book that she had ghost written. Let's see. I think it was last week, so let's see if we can find it. Okay. Not sure if we saw this one or not before, but let's do it again.
Did they catch a glimpse of their father taking his last breath? It's torture to think of. Why did Eric lose his life? Why did the boys lose their father? Was it because of Corey's greed and desire to get life insurance and other assets? If so, that is abhorrent. How could anyone value human life so cheaply? I cannot comprehend it. I'm overflowing with grief and pain at the thought that Eric meant so little to her. If Eric had died because of an illness, he would have been cared for. He could have looked after him and been with him. If he had died because of an accident, people would have tried to help. There would have been kindness. But there's no comfort to be had here. There's no consoling thought in the way Eric died. In his last moments, after being intentionally poisoned, he was faced with betrayal and terror. The thought of it is unbearable. I am haunted by the horror of it. This last year has been a living hell for our family. We have watched as Corey has paraded around portraying herself as a living widow and victim while trying to profit from the death of my brother.
Oh.
Both by trying to profit from a book about his death and trying to get life insurance and assets that should go exactly where Eric wanted them to his boys.
So this is the story of Corey and Eric Richens. Eric is dead. He died from fentanyl poisoning. Prosecutors say it was his wife who got the drugs and then laced his drink with it and killed him, murdered him for money, all about money. So I want to give you a little background about this couple. Now, he was very successful, had a stone masonry company with a partner and did really well. When he met her, she was working at Home Depot. Once they got married, they started a family. She started a business. She wanted to get into real estate, flipping houses, you know, like they do on HGTV, and was going to try to, you know, make her mark and in that. But apparently, business wasn't great, according to prosecutors, and he was no longer going to prop up her business with his money, and he allegedly caught her trying to get her hands on some of his money. And what he did is he created a trust and suspected his wife was perhaps trying to take his life and left everything to his sister. And that was the sister that you heard coming into the segment at the bond hearing for her. So there's a lawsuit by her now because she's trying to get her hands on all of the money that was left and the assets that were left after Eric died. But she's in charge of the estate. So there's this big battle going on. And now, after she sued the estate has now counterclaimed and sued her. Take a look, some of the allegations here. The Richens estate versus Corey Richens. They allege that starting as early as 2016 and perhaps earlier, Corey began having serious financial troubles. Corey was taking money from Eric's bank accounts and running up debts on credit cards in Eric's name and without Eric's knowledge. As of February of 2022, Corey or her business owed at least $1.8 million to hard money lenders. And in the days prior to Eric's death, she had at least 7 phone calls with one or more of those lenders. Eric confronted Corey about the stolen money, and Corey admitted she had taken the money. So now there's these cross claims going back and forth, but meanwhile, we've got a murder case. So how does all of this play into that? Because Corey Richens on the one hand saying, hey, I'm entitled to this money. I'm entitled to the estate. And her sister saying, no, you don't get that. And by the way, you owe the estate money because you were stealing money from him when he was alive. Let's bring back in the think tank. Daryl Cohen, Molly Palmer, Josh Schiffer with us. Josh, you look like you want a piece of this one. This is horrific, right?
I've been warning people about the dangers of marriage for years. It is absolutely impossible to be a victim of a spousal murder if you remain dedicated and single. No, all kidding aside, this is a nightmare. This is betrayal upon betrayal upon betrayal. But in a weird way, it helps her criminal defense because this civil case muddies the water and shows how this wasn't the first conflict between Sis and Corey. You're going to be able to mine, as a successful defense attorney, a story of a family.
So wait, you're saying that this fight between the sister and the estate and Corey is going to somehow help her? The sister is an important witness in the case, by the way.
It feeds into a defense.
I mean, the sister is going to be a witness for the state. And so, yes, you can certainly go down this line of cross-examination and show how she was, you know, she had hatred for Corey or something along those lines. But personally, I don't like the optics. If my client is on trial for murder, I would not like any collateral evidence of her suing her late husband's estate, trying to get some portion of the money. I think that is basically a motive.
Well, should the jury hear about all this? Will they?
I think they're going to hear a lot of it, that some of it may be excluded, but the optics are bad. And where did he get the fentanyl? Did he go buy it? Was he a drug addict? Did he do this on his own? How did his wife get him the fentanyl? And that's something the prosecution is going to have to show.
Well, they've got the witness, you know, but not the greatest witness. You know, someone that worked for Corey who has other legal issues is going to be the one saying, yeah, she asked me for the fentanyl and I got it. They're going to allege that perhaps it was laced in a Moscow mule. That she fixed for him.
Stay away from
cups.
Putin. Stay away from Putin.
Yeah. So
The issue is that it's a classic American story, but you can spin her position so many different ways. And by adding this, I totally agree with what
now, when you
Molly's
say
talking about.
spin, does that mean like mislead the jury?
No, it
No,
means
just a little spin.
tell a version of the story. If you have a complaint about spin, let's go talk to all your government buddies in the prosecutor's office. They're the ones out there putting news stories out in order to set a narrative before the defense even has a chance to get their act together. That's spin. That's manipulation. What we've got is a woman who one day found herself without a husband due to his death by some sort of poisoning, and she's involved as the accused. And now she has to protect herself, her own best interests, and she's trying her best. There's a lot of hay that can be grown on their relationship dynamic in the family, the unequal finances, the hard money loans. There's a lot to talk about. Every time you talk, you're adding the opportunity for reasonable doubt to grow.
I disagree. I think that you've got a motive. How much money from her husband did she steal? How much money was she trying to steal? And oops, you got caught. I didn't mean to get caught. Honey, you got to go. You want a drink? Call Putin.
Okay, Daryl. Here's the thing. I think this is one of those cases where you have to be very careful in jury selection, right? We're Salt Lake City. Could you find jurors that are not going to be so put off by the fact that she is litigating the estate while at the same time she's accused of murder? You might be able to put together a panel of 12 who say, look, in the face of such tragedy, we still have to deal with the finances. And then you spin it, as Josh referenced, and you focus on the other evidence and the fact that potentially he did poison himself and there's not enough evidence as to the actual murder and all of that. But the finances are certainly going to have to be dealt with in an artful way. And some
Because
of that,
it's central to the entire case, because the motive here, the alleged motive is the money, that she needed the money. And it was the only way she was going to get it, is by killing him. And now she doesn't have the money and she files the lawsuit. So it's almost like the lawsuit is part of the motive.
Well, it was the motive that they decided at the beginning. Remember, there can be new motives brought up. For all we know, they're going to claim some sort of violent confrontation over the theft, the catching her. There's a whole story that can be written there that can then point an investigation in a completely other direction.
All toward her.
And the bottom line, though, you believe the jury will hear about this little battle here and these
Absolutely.
allegations
Oh,
going back and forth.
be a part of it,
Absolutely.
right?
It's intertwined. They have no
All right.
choice. It's
And we'll
part of the
continue to
case.
track it, obviously.
Okay, let's go back over to the Great Wall of Ham. Yeah, they just said that this was a Salt Lake City case, but it's in Summit County, which is the county seat is Park City, I believe. The hearing was held at the courthouse, which is in the Silver Summit area over by Park City, and it's maybe a 20-minute drive. And one of the civil suits against Corey is filed in Heber, which is even further away, and still the same county, but unless they do a change of venue to Salt Lake County, No, this case is Summit County. So, and they managed to get a jury paneled for the ski accident trial, and so I don't see that they would have an issue with being able to find a jury. I mean, Park City's getting quite populous these days. I remember when I went working cleaning condos back in, must have been around late 80s. There was only one stoplight in Park City. Oh, things have changed since then. When I was a kid, we'd go up there. It was still, you had a lot of the old ghost town structures, but it's all, you have to be a millionaire to live there, because the houses are that expensive. I mean, houses in Utah are ridiculously expensive as it is, but up there they are astronomical. So I think the highest or the most expensive house in the state is in Deer Valley. And so I don't see a change of venue. Things could always change, though, and if it did, that would be great for me, because it'd be a lot easier for me to get to, because I could just hop on the tracks and go to the courthouse. But I don't expect that to happen. Let's see if we've got anything else which has cropped up on YouTube in the news. Let's see. Oh, this is an upcoming case here, which sounds intriguing. It's being called the ballerina case. I guess it's a former ballerina who is accused of murder, and she's claiming it was self-defense, but it's a little hard when the guy's wound is in his back and not his front. So let's watch that while we're waiting.
So we were talking about the end of the hearing on September 17th, 2020, where Judge Moreland made a oral order.
Correct. She made an oral ruling at the conclusion of the hearing.
And was the defendant present to hear this ruling?
Yes.
She was in court then?
Yes.
All right. I'm going to show you State's Exhibit number 1. Do you recognize that?
I do. Those are my initials.
Okay. What is it?
That is the CD of the oral pronouncement at the end of the injunction and emergency time-sharing hearing.
And you said these are your initials. So
correct.
When you listened to it, did it accurately reflect your memory of what was said in that hearing?
Yes.
State would enter into evidence State's Exhibit 1.
Same objections?
Yes, sir.
Yes, sir. Overruled for the same reasons. I'm not accepting it for the truth, just the effect on the listener.
Okay. And then the state will publish it's about 10 minutes long.
I think Mr. Sessions start with that one thing, even though I find it very reticent to ever say, well, someone else investigated this, so there's no problem. But I do appreciate the fact that Mr. Sessions argues that people investigated and found that his client weren't wasn't the perpetrator of any domestic violence, etc. Because I just read a report by a doctor that just indicated that he had done a full battery of psychological evaluations on Mr. Benefield in this particular case. He had absolutely no concern of self-harm, domestic violence, or any other type of spurious activity on the behalf of Mr. Benefield. Let me just go ahead and say as follows, that this court will find that as far as credibility is concerned, I would find, and I'm going to say this in the gentlest form I possibly can, that there is absolutely not a single scintilla of credibility that I'm attaching to anything that was testified to, at least in this hearing of Ms. Benefield. Court finds that it starts from basically the absurd of the conversations of what she would have had with a child, searching the room, finding a shadow box, being so upset, but also at the same time the testimony where she said, well, they absolutely liked me a lot. They confided in me every conversation. I knew all these horrible things were going to happen because the girls felt good talking to me. We then move forward to the actual presentation that she's had in this courtroom since she entered into this courtroom, the turning on of tears when she thinks it's appropriate, and then we move on to the entire insinuation that there is some type of poisoning going on in this particular case. There is not a single scintilla of credible evidence that Ms. Benefield has ever been poisoned or suffered from any illness of any poison. Court finds that Dr. Hilliard's testimony was suspect. I don't think that the court finds that he reviewed one record appropriately. And in comparison to Dr. Sawyer, I think his testimony, in a word, was bunk. I do find that Dr. Sawyer's testimony was quite informative, and that his information concerning the answered questions that I had, how there were testing for certain metals on and then testing for certain metals that weren't there. And most important to this court was the explanation of the misinterpretation or the use of an improper range, which I think even in cross-examination, there was a misunderstanding that there is a range of these metals are in the human body, not just a single number. So that brings us to the following timeline. I have that in 10/20/2016, there's the he goes up there. I mean, the respondent he's had back surgery. She moves back into the respondent's home permanently on December 2016. That in about January 2017 through, I'm going to say 5/8/2017, there appears to be a marriage in which there are arguments, and but there is still a very committed relationship to the point where they're talking about having a reversal of vasectomy to have a child. That on 5/8/2017, the clear evidence is that there is the vasectomy alteration or reversal, and that from that point they begin to pursue having a child. The court will find there is one incident of alleged domestic violence, and I got to tell you, it is de minimis, even though it's huge. Whenever how it was executed, the shot into the ceiling, court is going to find that at no time was the shot by Mr. Benefield at or in the direction of Miss Benefield. The court has seen Mr. Benefield testify, and the court finds that Mr. Benefield is taking on responsibility for that single misstep. But that is a remote type of domestic violence that has occurred. Subsequent to that, it is clear that Ms. Benefield continued to pursue a relationship and to have child with this gentleman, that she had a lavish wedding, invited numerous people there, had many people that she could have confided in, saying, I'm in a hellish situation, things are out of control. Just last week, he shot a bullet in the ceiling. That's absolutely not what happens. Instead, she goes through with this lavish wedding. She goes on developing a ballet with her husband at that time, posing in magazines, portraying to everybody in the world that this is a very happy marriage, that we're going down, we're going to start this national ballet at a significant cost, both emotionally, physically, and financially to the parties. that she finally they finally find out that in July 2017 they have conceived a child, and that or they think that that's the date they've conceded in retroactive review, which tells this court that during that period after the shot, that they were still engaging in a intimate relationship. The court does not find credible any type of animal cruelty in this particular case, nor does the court find that the other incidences alleged of punching the wall were ever directed completely at her, nor were they meant for intimidation. Court's also going to find that 8/3/2017, they do find about the pregnancy. It's confirmed, and at that time, because of illnesses due to the pregnancy, it is determined as a family, as well as because of the ballet, that they're going to move Miss Benefield to Florida from South Carolina. During all this period of time, what we have is a household that is continuing on. Miss Benefield being in the home, not making anyone alert. The medical records are devoid of any conversations between her and people that would have been providing protection, those being doctors, etc., indicating in the least that she has any type of poisoning that is appearing in her system, that she has been the victim of domestic violence, and or that this child, Eva, has been the victim of domestic violence. Then we go on, and suddenly we have, she moves to Florida, but even in Florida, we have Irma come through, I think September 11th, that weekend. Mr. Benefield comes all the way down. He makes sure she has a generator she needs for the storm. He then leaves, and she feels comfortable enough and well enough to go all the way back up to the home that she shared with Mr. Benefield to collect property and transport those items down to Florida for her own use, and without any fear that this gentleman is going to harm her when she's up there. They court will, one of the other things allude to as far as credibility problems were the issues concerning the split records that she's asking the Lakewood Ranch to have to, I guess, somehow cover any type of problems or contradiction there might be with the poisoning allegations, as well as the emails that were introduced today between the cousin of Mr. Benefield and Miss Benefield, I guess, trying to curry some kind of upper hand in the in either of these two cases against Mr. Benefield. Court's also going to find that the wife has at this time demonstrated a complete disregard for allowing Mr. Benefield to have any active role in the birth of his child and or the life of his child, that he has now not had any contact with. Court's going to find there's been no violation of any injunction. The court did that and has listened to the testimonies that were provided concerning the injunction that was entered. Quite frankly, it sounds like the court was, when you listen to the transcript, was actually telling both of them they needed to stay away from each other, and that certainly there was no violation of it whenever there was the oral pronouncement, only to be followed by a written pronouncement. Court is also finds there are some issues with the credibility of Miss Benefield when she's actively sitting here telling this court she doesn't like to have publicity, but at the same token she's participating in articles concerning the alleged poison, etc. As far as the last comment on the poisoning, there is not one piece of evidence, like I said, it has been established that even if she was being poisoned, that there has been a suggestion of a nexus of the who, how, and where the poison. That would be rank speculation for this court to jump into the idea that because it happened, it had to be him, especially when I have, in all senses, not a credible witness is the only person that's asking me to speculate. So with that in mind, the court is going to find that at this time, there is absolutely no evidence. And I'm saying no evidence. I'm not saying by the preponderance of the evidence standard, that hasn't even been close to that there's been a indication that there's an immediate likelihood of domestic violence. There's only the one remote incident. And as of today, there's no reasonably prudent or logical person would think that you're the threat, that you're being threatened by immediate domestic violence. So for those reasons, the court is going to deny the request for an injunction in this particular case.
So after the judge's ruling on the injunction, which would be the defendant's motion, did she make a ruling on your motions?
Yes,
And that was time sharing with the child?
it was time sharing and parental responsibility.
Okay. And what was the order, or what did the judge say Doug could do?
There was a temporary time sharing schedule that was increasing in frequency and amount. So it started with the first day that he was going to be able to meet his daughter, just a handful of days later. After a period of time of seeing her according to the schedule, then it jumped up to weekend time sharing, overnight sharing. Then there's another jump. And so he was able to take his daughter back to South Carolina for time sharing. There was also, I believe, some extended visits, maybe holiday related, but then the other main component of that order was with regard to shared parental responsibility, which again is the decision making. And Judge Moreland ordered that Ashley and Doug were to exercise shared parental responsibility so that they would have to confer and make a good faith attempt to agree on major decisions. But the court specifically ordered that Doug Benefiel would have ultimate decision-making authority regarding health-related or medical issues. And the order made very clear findings about her extreme concern with regard to Ms. Benefield's medical decisions up to that point, which is why she ordered the ultimate decision-making authority.
And the concern was for the medical decisions for the child?
Correct.
Okay, court should be starting any minute now. I'm trying to figure out what exactly made YouTube grumpy earlier. See if we can't get that taken care of. Let's see. So I'll just leave it there while I try to figure out how to remove this. Okay, I think I've got this section which made YouTube grumpy and stopped the stream earlier. They were saying something about violating community standards, and I'm not sure if it was the reviewing the press conference or the other clip that I was playing while we were filling in time. But we are back to the Great Wall of Ham here. The state rested, and the defense wanted to get the medical examiner's testimony thrown out. The judge didn't sound like he was going for it. There seemed to be some confusion over in the law and crime chat. Some people thought they had 10 minutes to come up with something, and obviously that's not the case because it's been like over an hour now. So I think that, you know, he didn't say as much, but it's turned into an extended lunch break, which is just as well because yesterday's lunch hour took more like 2 hours. So, let's see. What yesterday the final witness was utterly fantastic. If you haven't seen that, I recommend watching the. I think he was on the stand for like 3.5 hours. So I recommend reviewing that. And maybe we'll pull that up and look at that while we're waiting for the thing to come back on. Let's see. Because that last witness, the examination was masterful. Let's see. Looking to see if one of the, let's see, let's do filter. So we get just yesterday's. Let's see if I can find that. I'm going to mute for a second while I look. Hello, Delene. Hi, Where the Wind Blows. Yeah, we ran into a little technical difficulty with the stream I was doing this morning while killing time, and ran afoul of I guess the algorithm objected to something, and so I'm currently editing that segment out so that we won't have any issues. But I've got the segment here. Or no, I've got the video here from yesterday. Let's see if we can get to where the last witness came on. Okay. I think we got it here. Let me turn it up.
Exhibit 61. That is a CVP surveillance. And that you're familiar with that? Yes, I am. Okay, you can turn it over. States Exhibit 65.
This isn't the beginning of his testimony, but I think I'll just let it roll from here.
This is the Border Patrol Station. I'm sorry, this is a Chick-fil-A, 5118 McPherson.
Is that in the video compilation?
Yes, it is.
I'll show you States Exhibit 57. What is that?
This is video from the Father Magno apartment.
Is that in your video compilation?
Yes, it is.
States Exhibit 74. Are you familiar with that?
Yes, this is a video from Finley Elementary School.
Is that in your video compilation?
Yes.
States Exhibit 54. Are you familiar with that?
Yes, this is video from the Metro T-Mobile.
Is that in your video compilation?
Yes, it is.
I'm going to show you States Exhibit 59. Are you familiar with that?
The Melton Truck Lines? Yes, I am.
Is that in your video compilation?
Yes, it is.
I'm going to show you States Exhibit 60. Do you recognize that?
Yes.
What is that?
It's a video from Los Encinos Town Hall.
Is that in your video compilation?
Yes, it is.
Okay.
And I don't know if you, but these were presented by the state.
Correct. 2 days ago, but they also, not only was it an exhibit in the form and the number like you say, but there's also, I'm assuming, sub-exhibits within each one of those. I just want to make sure that are those the ones? You don't have to name them because
Okay, I'm looking to switch it here since it's too quiet. Let's see, where did it go? I had it pulled up. Where did Okay, here it is. Okay. Let me mute me while I look for the video to start this segment. Okay. Okay. I think this is about it. So, whoops. Need to share the screen again. Okay. Here we go. Okay, that was an in-camera hearing. This
I met up with BP agent Lara near the soccer fields. Then drove upriver and saw a person laying on the floor. I called BP Lara to assist. We then hard to read that word. Female, and attempted to talk to her. I called EMS and they advised she was dead. We did a perimeter sweep for safety and found some shoes, a stroller, and a second body. PD showed up on scene and assumed custody.
On the second page of exhibit 532.
Yeah.
The signature
Yes.
and dated.
4/9, April 9, 2018.
In addition to interviewing Mr. Burgos, you mentioned that you interviewed other individuals, one of which was Amy Burgos.
Correct.
Now I'm going to, may I put you on?
Yes.
I'm going to show you what has been marked as State's Exhibit 535 and ask you to recognize this.
Yes.
Tendering 531 to the defense for review. And offering to others. So State's Exhibit 531.
objection? No objections.
Now,
Admitted.
thank you, Honor. Detective, did you conduct any other tasks regarding this investigation?
Yes.
What were they?
We did a second, or we executed a second search via search warrant at the same address. I think it was the 25th April.
So I'm going to show you what has been marked as State's Exhibit 531. And this is, will you tell the jury what this is?
This is a consent form, waiver of search warrant and authority to search. So in essence, Ms. Burgos was given authorities consent to search our home.
And did you in fact, were you part of this search?
Yes, I was.
And that was, when was the first day that you went and searched Mr. Burgos' home?
The 9th, the same day of the homicides.
And what were you looking for?
Anything that might be related to the crime, like bloody clothes, sharp force objects, maybe even electronics, anything that we might be able to place or that might have been used during the crime scene.
And then that you conducted a second search on the 24th or 25th?
I believe it's the 25th, but I can check my notes if you want.
Now, did any of those searches yield any evidence related to the crime?
No.
Did you conduct anything else regarding this case other than interviews and the searches?
Just the following day, myself and lead detective Garcia accompanied the medical examiner investigator to the Nueces County morgue with both bodies and were present for the preliminary autopsy.
I pass the witness, Your Honor.
Good morning, Detective Reyes.
Good morning.
Detective, I'd like to talk to you about the point in time when you, Officer De La Cruz, Sergeant Lozano, and Mr. Burgos were standing around the white Mercedes Benz. At that point in time, you learned from Detective Raimundo Garcia that Ronald Burgos' full name was Ronald Anthony Burgos-Aviles, correct?
Which moment specifically are you asking about?
I'm asking when Detective Raimundo Garcia, I believe, called you on the phone and notified you that the full name of the agent was Ronald.
Yes, sir. After the phone call, he provided the full name of the defendant.
And you asked Mr. Burgos to tell you his full name, and he answered Ronald Anthony Burgos-Aviles, correct?
After the phone call.
Yes. Now, prior to that time, Mr. Burgos had handed his driver's license to Detective Garcia, correct?
You want to know what I knew at the time or what I know now? At the time, I didn't know.
At this time?
Yes.
Okay. And Detective Garcia had returned the driver's license to Ronald Burgos, correct?
Apparently, because they found it in his shirt.
Right. And during this conversation, Ronald Burgos tried to rest his hands on his gun belt. Do you remember Officer De La Cruz saying that? Oh, you.
Without the ones like you working tirelessly to keep things running, everything would suddenly stop. No matter your industry, Grainger's here for you with professional-grade supplies. Call, click Grainger.com, or just stop by. Grainger, for the ones who get it done.
You know, I don't know if he lowered it. You know, I would have taken further action. But, you know, we were, like I said, we were on high alert. And of course, had I felt the need to maybe draw my firearm, had he done that, I would have. So, you know, I don't necessarily remember him pulling his hand down towards his weapon.
Do you remember Officer De La Cruz sweeping Mr. Burgos' hand away from his gun belt?
You're going to have to, can you please explain that sweeping? What do you mean?
Yes. Did you see Officer De La Cruz move Mr. Burgos' hand away from Mr. Burgos' gun belt?
You know, he's going to have to, he has to answer that because I was concentrating on what I just explained, and I'm not sure exactly what all Mr. or Officer De La Cruz, what action he took.
Okay, but the bottom line is that Ronald Burgos did not resist being detained, correct?
You're correct.
You told him to put his hands on the car and he complied with that, correct?
I grabbed his right arm and I placed it on the hood, and he didn't pull back or anything. So
And he immediately unbuckled his belt. An officer De La Cruz was holding it from behind Mr. Burgos, and he held on to the gun belt, correct?
that's correct.
And Mr. Burgos did not resist or attempt to flee, correct?
Correct.
And then he was taken into custody, and you were there when Mr. Burgos was placed in the patrol unit, correct?
Yes, sir.
And he asked to remove his border patrol shirt because he thought it was embarrassing for a border patrol agent to be detained in a police car, correct?
I know that now. At the time, I didn't know, but
Okay.
I know now.
And you did not see any blood on Mr. Burgos' hands, correct?
On his hands? Well, yes, I did. I mean, he had that laceration on the inside of his right thumb, and
You were talking about that little scratch on his thumb, right?
yes, sir, there was blood on that,
Right.
and then he had some other cuts, small cuts on his elbow, right elbow. A little bit of blood on that.
I think that's what Officer De La Cruz described as red marks on his arm. Did he describe them as such to you?
I don't know how he described it. I just know that the inside of the red thumb, it looked like the blood had even maybe ran down a little bit from the scratch.
Did you or anybody take a swab?
The CSIs did. I did not. It's not my job. That's for the crime scene investigators.
But not right there when he was detained. That was later at the police station. correct?
Exactly. I didn't swab him right there at the scene.
Because really, it was just a red mark. There wasn't enough blood for you to swab. Isn't that true?
Oh, absolutely. No, there was plenty to swab.
Did you see any blood on Mr. Burgos' clothes?
I'm sorry, on his clothes?
Yes, on his clothes.
I didn't.
How about on his the rest of his body? You mentioned already the red marks on his arms, but on the rest of his body?
No, I think it was mainly the inside of the thumb and the right elbow, inner elbow, upper arm area.
And then Mr. Burgos was questioned at the police station from around 3:15 p.m. on April the 9th, 2018 until around 4 a.m. the following day. Isn't that correct?
No, sir. It's not correct.
No?
No, sir.
Okay. What time did he arrive at the police station, if you recall?
What time did he arrive?
Yes, sir.
I believe he arrived.
And we've got a sidebar.
And speak up loudly into the mic so the court reporter and the jury can hear you. Okay. Please state your name for the record.
My name is Raimundo Daniel Garcia.
And how are you employed?
I'm employed by the Laredo Police Department.
How long have you been with the Laredo Police Department?
Approximately 19 years.
Are you a licensed peace officer?
Yes, I am.
Okay. And what are your current what's your current assignment?
I'm currently assigned to the Laredo Police Department Crimes Against Persons Division.
What are the duties of a crimes against persons detective?
We investigate crimes against persons that include, but not limited to, misdemeanor harassments all the way to capital murders.
Speaking of capital murder cases, are you familiar with the case of Grizelda Hernandez and Dominic Hernandez?
Yes, I am.
And how are you familiar with this case?
I was assigned as lead investigator to this case.
As lead investigator, what does that mean?
It means investigation. We try to answer the why, the what, the who, the where, the how, pertaining to the crime we're investigating.
And as lead investigator, do you have a team of other officers assisting, and what is their role in comparison to your role?
Yes, yes, we do. It's a collaborative effort between investigators in the division. Each of us, have a job to do. Usually, that's delegated by the lead investigator.
So you say that it's delegated by you in this case, correct?
Yes,
And everything done by everyone in this case comes back to you.
yes.
Okay. So how did you become familiar with this case?
By hearing it on the radio.
And you heard it on the radio, and were you aware of the 911 call being made?
Yes.
Okay. What information did you have?
We had, it was a call for an injured person with a laceration to the head and possibly dead on scene.
And did you respond to that call?
Yes, I did.
Okay. You remember what time the call came in?
Yes, I believe at the 11:33 a.m.
Okay. And what did you do as soon as the call came in?
I responded to the scene.
Where was the scene?
The scene was located on a dirt trail west of the dead end of Bristol Road and Allen Drive.
Okay. And for geographic or landmark purposes, what is this area known as, and where is it?
It's known as the Father Magnable Park area.
Now, arriving.
Court seemed to have gone back in session. For some reason, that tab was running a little behind the current, so they talked a little bit, but it looks like, consistent with usual, we have come back in the middle of a sidebar, so I don't think the jury is present yet. Let me just take a look at. Looks like they started about 9 minutes ago. The judge is talking, lawyers talking, lawyers conferring in a huddle, judges talking. So, oh, let's see, we got it muted here.
We'll leave the defendant out here. Don't even if we take a break, just leave him here because he might have to consult with counsel. Just leave him here, and then and that it'll avoid also the traffic that we may have in the hallways with jury going out in the restroom and whatnot. So. You do have each of you have a copy of the transcript of that portion of Dr. Stern's testimony during direct, both the direct and cross. All right. Thank you for providing that, Cindy. Let's see what else. I have it, yeah. Again? Okay. That's probably the last one. Okay. Oh, so she's literally driving over here. All right. Um, so then let's do that. You think it'll take you how long to publish? About maybe 10 minutes or so, or? Yeah, yeah. I mean, you're just gonna be saying these are a page whatever of exhibit whatever, and
Yes, sir. So it may be even shorter. It is literally 5 pages that I intend to put on the book.
and just leave it there long enough so that they can perhaps read it. All right. And that's defendant 7, and it'll be offered while they're here. And there's no objections by the state. All right. Okay, so we got a little timing issue. I think we just, oh, maybe you can ask her to park up here. Just drive completely up here. And then just have security, allow her to come up here on your end. All right, thank you. Just find out what she's driving. She's probably driving a truck. I'm just guessing. Okay, so trying to line it up so that we can, either way, we're going to have a whole bunch of breaks before we read the charge to jury, because we have, obviously we have the break in the morning. We're going to have a break right now while we either, because we can't sit here having the jury here wait for 20-30 minutes. So I either just keep them going, leave them there for a few more minutes, I hope, but a few more minutes, meaning could be 30-40 minutes. So, or bring them out and take them back in. Either way, and then we do the direct on the doctor, on the recall of the doctor, right? Not even a recall, you're calling her as a witness. And then you examine her there, and then if you rest at that point, and I'm not holding you to that, but if you do rest at that point, then I gotta take the jury out, and then we gotta officially do the charge conference here, and then make my rulings, print out the charge, and take the jury out and come right back in. So that's basically the timeline that we're looking at, just so that whoever's wondering. So I suspect that the charge, and totally guessing on the length of the examination of the doctor, we're probably looking at maybe reading the charge to the jury around 3:30. So just a total guess on that. So we'll take it from there. I think we're going to have to do it at the end anyways, because if there was a particular language that they were asking for, perhaps I could do that now and then give my official ruling right afterwards, which is sometimes what we do. But there is no language that they're asking for, no additional charge that they're asking for, other than just arguing some of the language. And perhaps if you all already know what that is, you've conferred on it already. So if there, it does give you more time to confer on that if you haven't already with regard to some of the language, and perhaps they'll agree to change whatever it is. So maybe I'll give you some time to look at that again and then confer on some of the wording or whatnot. It might be just some wording problems, and therefore may not be much of an argument on that.
I think there are two small matters we'd like to discuss with Your Honor, but other than that, we're in agreement.
Okay, so then that's, and you want to wait till after we're done?
I think we could confer.
All right, let's do it now. Okay, so I have a copy of the charge on my screen. And again, we're anticipating that there's going to be one witness called by the defense and no other. If there is something in the charge that in fact will require that witness to testify before we make a decision, then we'll wait on that. But other than that, we can do it now. And you all are in agreement to do that. Is that correct?
Yes, Judge.
I'm sorry.
Yes, Your Honor.
All right, thank you. All right. So let's, we have a proposed charge that's been filed by the state. Has it been filed? Or I know it's been handed to me.
I know it's been handed, Judge. I don't believe it's been filed.
Okay,
by
so
the
it's been
state.
handed to both. I'm going to work with the copy that I have. In fact, let me see if I just print out this one.
Judge, just for the
Oops.
record, Cassandra.
I have a
that was for
red
the
line
state.
copy. Y'all have, let's see.
Yes, Your
I
Honor,
don't
that's
know
the
why I
copy-
got that.
That's the copy that we're working from. It indicates the changes that both sides have been.
Okay, so I would like to print this out without all the red line stuff that is in there. So if somebody can do that for us, please, and we'll take it from there, just so that I can file the copy we're working off of, and then I'll get a final one after we're done. You could, if you have it on you can email it over here
Yes, Your Honor, we're going to email it
to Alma Martinez. But one that's not, I know there's probably just a couple of buttons that we got to push to be able to not, maybe it's just a view button. Okay, so I'm going to work with what I have here, assuming that this is in fact the one that we're going to print out, and I think it is. So I'll file that copy, and then whatever changes are made to it, we'll make them on the record. And then we'll, depending on my rulings, changes are made, we'll refile obviously that one before we read it to the jury. Go ahead.
Yes, Judge. I believe that the first part, I don't believe we discussed this, but it does say the defendant, Ronald Anthony Burgos-Aviles, stands charged by indictment with the offense of capital murder. But since there's two counts, if we can just.
Could you put a copy on the almost,
Yes,
just
sir.
so that we can. Thank you, Mr. Son. And that way you can point at the area you're talking about.
Yes. So as far as this area, we would just need to add that it is two offenses. So here would be by indictment with two offenses of capital murder because there is two counts. I'm not sure if that would be an argument to make.
So where is that at?
It's the first paragraph of page 1.
Oh.
Right here, Judge.
Because,
Would be two offenses of. Let me just try to see them.
so there's two counts,
Yes, Judge, there's two counts.
so. Okay, was that something you all did not agree with?
No, Judge, that's just something that we noted right now whenever we.
Okay,
It wasn't raised.
it was not raised.
No. I mean, in our position is that it's two counts of the same offense. I think they clearly delineated it later, but.
And then it would, I believe on page 2, paragraph 3,
So now you're going to whatever you all are.
Yes, Judge, this
All
would
right.
be the
So
disputed part.
paragraph 3 of page what?
Page 2.
All right.
So on this paragraph, we wanted to add this language which says that they can consider all relevant evidence pertaining to the relationship that existed between the deceased and the defendant. I know that the legislature does have some precursor language as far as the Texas Code of Criminal
So
Procedure.
just so we know, this
Yes.
this is your proposed charge, and you want to add language to your proposed charge?
No, Judge, it's already on there. That was our proposed charge to keep it. I believe that they're arguing for us to remove that section.
Do you want to remove?
We would like to remove Roman 3, Your Honor.
We would like
Oh,
to keep.
all 3,
Yes.
and then you want to add the word relevant.
Yes, Judge. Just so that it
You want to
can.
keep 3 and add the word relevant.
Yes, Judge. Just so that it can quote the statute
All right.
directly.
Okay, go ahead and tell me why.
Yes, Your.
No, not you, her.
Yes.
Well, Your Honor, that is language proposed by the state. We were unable to find it in any pattern jury instructions, and our position is that it's duplicative of the first sentence of Roman 9 and highlights the state's theory rather than introduces any evidentiary principle or element of the crime which the state is required to prove.
Roman 9.
Which instructs the jury that they may consider all of the evidence, which, necessarily encompasses any evidence the state has introduced as to the nature of the relationship.
If you tell me where Roman, I don't have a Roman numeral 9 paragraph.
Your Honor, it is on page, for my draft, 8. I apologize, Your Honor. It's page 4 on my printout.
Which paragraph you
Roman 8, my mistake. You may consider all of the facts that are shown by the evidence and draw natural and reasonable inferences from such facts. We believe that encompasses the specific evidence to which the state is highlighting in paragraph 3.
And so she says it doesn't exist. I know I've seen it before.
Yes, Judge, I've seen it. We have it in our jury charge or our pattern jury charges, but that language we included in every case, the one that she's citing to.
Other than you including other cases. where else can you
Well,
get it?
not those. I'm saying like the other language we always cite as far as all the evidence, but since this is a homicide, it does change and the
Can
law
you tell
does
me-
give
can you
us.
Tell me the law instead of just giving,
Yes.
just reading the law.
So the Texas Code of Criminal Procedure, section 38.36,
Let me
gives
just highlight
this
it real
exact language. In all prosecutions for murder, the state or the defendant shall be permitted to offer testimony.
3836?
Yes, Judge.
One second. Thirty-eight, 36, A, B,
It's A, Judge.
okay. So, clearly, for purposes of bringing the evidence into the trial, you use this statute to argue it's relevant because the statute allows us to bring it in because all relevant facts and circumstances surrounding the killing and the previous relationship existing, all relevant facts and circumstances going to show the condition of the mind of the accused, the time of the offense. That gives you then opportunity to say, I can bring this in, I can bring that in, because it goes to the actual statute. And I guess what you're saying, Ms. Waddell, I hear you saying is that if you look at the pattern jury charges, that's not one of the optional or alternative paragraphs that you see there.
That's correct, Your Honor. And furthermore, our position is that that evidence was, as Your Honor indicates, introduced in the state's case in chief. It's covered under the first sentence of Roman 8, which instructs the jury that may consider all of the evidence which has been put before them. And to highlight that specific evidence would be highlighting the state's theory of the case in the jury instruction, which we argue is improper.
So I see what your concern is. In other words, if you highlight that particular instruction, it's in fact highlighting the evidence that the state has been wanting or has been introducing and want the jury to focus on, which is the relationship of the parties and the fact and circumstances and the condition of the mind of the accused at the time of the offense. And so what the concern then would be, what I hear them saying is, am I commenting or on the weight of the evidence merely by instructing them that they can consider it, is what they're, I guess my concern is, but is what they're, I think, saying in a different way.
Yes, Your Honor, that the instruction would in effect be directing them to particular portions of the state's case in chief to consider, in addition to being told to consider all of the other evidence that was introduced, which encompasses that specific section.
In other words, you're saying because paragraph 8 starts with, you may consider all of the facts that are shown by the evidence.
Yes, Your Honor.
And all of the facts mean everything that came in.
Yes, including the specific portions.
And Judge, for us, it would be that the statute allows them to consider more than, to consider the relationship where it wouldn't allow them to consider the relationship.
Well, that's not what the statute says. The statute doesn't say the jury may consider. The statute says the defendant shall be permitted to offer testimony. So this talks more about what you're allowed to offer as opposed to what the jury should be allowed to consider. The jury should be allowed to consider all of the evidence that was brought into the trial, period, and put whatever weight they want on the particular case. And you know, I'm gonna tell you the truth. We put this provision in there many times. So I don't think anybody's ever brought it back to our attention. The problem with this case is that it's a death case, and you're gonna have so many eyes looking at this case, and so many people reviewing it, and they're gonna hinge and on every single word that we've said so far, everything that was said during voir dire, anyone said any part of this trial. And would this just be adding an additional point? And I think that's what I'm concerned about. Clearly, you're able to bring it in. Okay. Unless you all show me something that in fact says that it's been looked at and trampled on and reviewed by the Court of Criminal Appeals before, or even our Court of Appeals here, I suggest that we just leave it out.
Okay, so Judge, we do have, okay, yes. Judge, we do have the jury chart, I'm sorry, the jury pattern chart here, if I can just.
Go ahead.
And this is for the capital murder. You are instructed that in considering your verdict.
Paragraph 4 of that particular.
So it says capital murder, it's
Yeah.
under capital murder. And then the language is right here.
All right, and is that the pattern jury charge that you're showing me? Can I see
Yes,
it?
Judge, it's the Texas criminal jury.
All right, thank you. Okay, so I said, unless you show me, there, you showed me, and your request then will be denied. Let's move on to the next one.
I believe there's only one other matter that we wanted to raise. It's my understanding from the state that they do not dispute this addition necessarily, but wanted your Honor's opinion on it, which is in the instructions as to the count 1 and 2, in the second paragraph of each on page 3 under Roman 6, we would request that your Honor instruct the jury that unless you so unanimously find beyond a reasonable doubt, the instructions as proposed to us did not include the requirement of a unanimous verdict. We believe that's required by law.
I think she added it.
Judge, it's on there. I've just never seen it. I just wanted to get your Honor's
Well, I mean, if you
response
added
to
it, And it's your proposed charge?
No,
She
Judge,
wants
that's
it
not
on-
our proposed charge. Those were some of the changes. We just highlighted that part. This is already a merged version of both.
Hold on. You didn't add it?
I believe that that one's already a merged version of both defense and state's arguments as
So
to.
you don't want that?
We're just looking for
Okay.
maybe some
That's okay.
instructions on that.
All right, let's look. Okay, can I look at the paragraph right before that? Oh, let's see. Let's here we go. So it's the application paragraph, basically.
Yes, Your Honor.
I mean, it is what it is, right? I mean. they
Yes,
do have
Judge.
to
I mean, I just
unanimously
wanted some
find-
guidance. Oh, sorry.
They do have to unanimously find that beyond a
Mhm.
reasonable doubt. I'm fine with that. I'll just leave the unanimously in there.
Okay.
All right, we'll leave the word, you wanted it in there.
We did, we added it in, Your Honor.
Okay, so we'll just leave it in there.
Okay.
Is there anything else? Mr. Solomon?
And Your Honor, I apologize. I know I indicated several minutes ago that we were not going to request any additional instructions. However, we would like to request that Your Honor also instruct the jury in our book, which is an outdated manual, so I'm not sure if it's numbered differently in the state's copy, but in the 2018 version of the criminal pattern jury instructions, it's 9.16, instruction on warnings and waiver.
Without the ones like you working tirelessly to keep things running, everything would suddenly stop. No matter your industry, Granger's here for you.com or just stop by. Granger, for the ones who get it done.
And it is on page 233 of the 2018 edition of the criminal pattern jury instruction.
Give me 1 second. So which portion of the whole thing?
Yes, Your Honor.
Give me 1 second. Okay. Can you scoot up a little bit? Okay. I mean, there was a statement made, the evidence is going to show that there was an oral statement made, and I mean, if they ask for it, they have to have it in there. I don't think there was a lot of issue made with regard to the voluntariness of the statement, but I guess you could make an inference or an argument of some sort. There was a suppression hearing earlier in during the litigation of this case, so where arguments, I guess, were made during that time. All right, so you're gonna type the language out and send it to me, please? That way I don't have to type the language.
Yes, Your Honor.
And send a copy to council.
Yes, Your Honor.
Other than that, is there anything else?
No, Judge, I believe everything else.
Any particular place where you'd like that language? I take a look at it and.
Your Honor, I don't believe we have a strong position, but I would propose placing it between the application paragraph of count 2 and the paragraph now titled Roman 8.
Paragraph what?
Roman 8, page 4.
Okay, so right before 8.
Yes, Your Honor.
I guess I want to, well, you know what? There's no Roman numeral 7, so I can put a 7 there.
Perfect.
Right? Looks like it. I think you left 7 out.
Yes, Judge.
So there's a 7.
There's a 7.
Okay. Okay.
So would Your Honor like me to include that in the current full charge of the court as Roman 7?
Yes, that'd
Okay,
be great.
I can do
And then just Is there anything else we took out? No, we didn't. We left unanimously and we left. Oh, we're gonna put in the
The two offenses at
right,
the
the
beginning.
opposite beginning. So then, can y'all get together on that language and then just send it to me and both of y'all?
Yes, Judge.
Okay, great, thank you. And I'll formally ask you. I mean, once we're done with Dr. Shaw, I'll ask you again if there's anything else in the charge, but I suspect that there won't be. So you need that. So I'll have the charge ready. Thank you. All right, so it's 1:53. We still have a ways to go with Dr. Stern, so I think I'm gonna just opt to wait and keep the jury there, and that way, once Dr. Stern is here, then we'll do it with her, and then you'll follow up with your defendant 7. You'll publish, and then you'll tell me whether you have any other witnesses or you rest at that time, and then we'll ask the state whether they close, and we'll send the jury out for a bit, and then be right back with reading them instructions of the charge. Okay, thank you.
Okay, what did he say about how long this was going to be? Let's see. See if somebody over on Law and Crime caught how long. People are going, another break? I need a drink. So somebody is observing, so there's no defense. They're still trying to come up with something, I guess. Let's see what else they're saying. People are crying out for a poll over there in the Law and Crime. Okay, let's go back to review the testimony while we wait, because yesterday's testimony was so compelling. Let's see. Here we go.
What time did you arrive?
I arrived at approximately 11:44. At 11:46 a.m.
Okay, so that's about 13 or 14 minutes after you heard the call.
Correct.
What happens, or what do you find when you arrive?
When I arrived at the dead end of Bristol Road and Island Drive, I was met by paramedics who were coming up from the dirt road. They were returning their equipment, their electrocardiograph equipment. I was briefed by them. They told me that there was a female on a trail. She was bloodied and she had no vital signs, indicating to me that she was deceased. I was led by the paramedics to where Grizelda was found.
What kind of trail was the body found in?
It was found in a dirt trail.
Who, if anyone, do you come in contact with?
Yes, I come in contact with several Border Patrol agents. There were 3 Border Patrol agents by 2 marked Border Patrol trucks. And also I came in contact with later identified to me as Supervisor Border Patrol Agent Ronald Anthony Bugos.
How did you find out that he was the supervisor there at that time?
I believe I had asked all the Border Patrol agents there that I asked them who discovered the body, and they all pointed at Ronald Bugos and said our supervisor did.
Okay. So what do you do next?
I proceed to identify the Border Patrol agents there.
And do you get to identify Mr. Bugos?
Yes, I do.
How do you do that?
I asked him for his driver's license.
And what does he do?
He hands me his Texas driver's license.
Okay. And do you get his full name in that Texas driver's license?
Yes, I do.
Okay. So after you've identified these Border Patrol agents and the supervisor, what, if anything, happens next?
So now, what happens next is we secure the scene, crime scene preservation.
Okay. And what does that mean?
That means securing the scene to minimize, contamination and disturbance of pertinent evidence.
Do you remember where Agent Burgos was when you first arrived?
Yes.
Where was he?
He was standing between the feet of Grizelda on the dirt trail and a white shoe that was located close to her body.
So he was standing in front of the body.
Yes.
Do you remember what he was wearing?
Yes, he was wearing his U.S. Border Patrol uniform, short sleeve. He's wearing a green Border Patrol cap. He's wearing his black boots, his utility belt with gun and magazines.
Were you able to determine that Mr. Burgos was on duty?
Yes.
How?
Well, I asked him. He was on duty.
And did you gather more information as to how he discovered the body? Did he say anything to you?
Yes, I asked him. Well, after I asked who discovered the body, and they pointed at the supervisor, Burgos. He said that I was working the area and I came across the body.
What if anything did? What if anything else did? Let me ask you this: did you notice anything about his demeanor?
Yes. At the beginning, when I see him by the body, he walks towards me and he's just fixated on the body. He's taking deep breaths. He's also grimacing, shaking his head, and during my contact with him, he did limited eye contact with me, and he was just fixated on the body.
In front of me? Okay. He's fixated on the body. Does he say anything to you?
Does he say anything to me voluntarily?
Yes, or does he ask you anything?
No.
What do you proceed to do next?
So I asked the question to all four of them. Has the scene been made safe? And knowing that the scene around Grizelda's body is going to be secured, I told the Border Patrol agents not to step on the dirt trail. But as soon as I asked, has the scene been made safe? I believe it was Dennison. He had a rifle with him, and he went off through the brushy area, to secure the scene. And one of the Laredo Police Department officers followed after him also.
At this time, you've already ascertained that he was the one that discovered the body, correct?
Yes.
Did he inform you that he had found any phones on Grizelda?
No.
Had he told you anything about a baby being found?
No, he did not.
Did he mention to you anything about him moving a shoe or finding a shoe?
No.
Did he mention anything to you about seeing a stroller?
At that time, no.
Did he ever come to ask you any questions?
Yes. Before Dominic's body was found, he asked me whether we had already identified Griselda, which I thought was odd because he had been with me, and it was, not even 15 minutes into my interaction with him. So yes, I told him that we had not identified the body yet.
So did he say the name? Did he say the girl, the victim? What was the words?
He said if we had identified the body. That's the words he used.
Did he volunteer any information about what he did with the body when you first saw it?
So yes, I asked him, given that I saw him in between the body and the shoe, and also from what I'm seeing, I saw the body had the dirt on the back. So that indicated to me at some point she was on her back. So I asked him if he moved or dragged the body in any way. He responded to me that he attempted to see her face to see if she was breathing, but did not drag the body.
Once the perimeter is secured, is that done with the yellow tape?
Yes.
Okay. Do you eventually get to, as lead detective, are you able to walk the crime scene with your CSI people?
Yes, once they arrive, yes.
If you can just visualize for us what evidence you're seeing as a lead detective on this dirt trail and the other subsequent items that were found by the other officers. What is
You have reached the office of Dr. Jeremy Manwine.
Well, it was a bloody crime scene. Griselda was laying in a prone position in a pool of blood. There was also blood droplets leading to where eventually Dominic was found. There was the white shoe. Later, there was a stroller that was found. Dominic and further south from where Dominic was located.
I got an appointment
there was
on the 11th.
the other white shoe that
See
was
if I
located.
could reschedule for a later date.
Yes, we did see some markings that we later associated with the stroller once we found it. Yes.
How many units were there? When I say units, kilo units. You know what a kilo unit is?
Yes.
What is a kilo unit?
Kilo unit is usually a truck unit for the Border Patrol.
Hey, yo, this is
the able to identify all these items that you just referenced to on the map?
When did you want to reschedule that
Yes.
for?
How about sometime in a couple weeks further out?
Okay.
Sometime in an afternoon, if possible.
Okay. Do you want to do Tuesday, July 25th at 2 o'clock?
25th. Okay, I don't see anything that day. So what time? 2 o'clock?
It's at 2 o'clock, yeah.
Okay, let's
I'm going to show you what's been marked States Exhibit 105.
get this in my phone here.
And it's got some blanks. You were just describing
Okay.
the jury, the crime scene evidence that you observed.
Yes.
Can you label these items or pieces of evidence that you saw with the proper name?
Okay, I've got it.
Yes.
Can you use
My phone.
Perfect.
Okay, thank you very much.
You're welcome.
Okay.
You have a good day.
You too. Bye-bye.
Thank you.
And where you're placing this?
Okay, well, this is a label that says female body, blood puddle. And this would be, do you want me to stick them on there? Or?
Stick it on there.
Can you see? This is where Griselda was located.
Okay. I'm gonna hand you another label.
Okay.
Can you read what that is, please?
This is a vehicle tire mark, and just south of Griselda, as you can see on the image, is the tire mark.
I'm gonna hand you a label marked U.S. Border Patrol units.
U.S. Border Patrol units. This is where they were located.
And you a label that says right shoe.
The right shoe, the right female shoe, was located on this side.
Showing you here what says stroller wheel marks.
Stroller. This is a baby stroller wheel marks, and let's say it would be right here. Can you? I don't know if you see the marks right there.
What do you mean where the stroller marks end? That's where.
So this would be where we last see the stroller marks.
Where it stops.
Where it stops.
Okay. And I'm going to show you this. What says stroller path.
Okay, the stroller path. This is where we started seeing the stroller path.
You also mentioned in your testimony blood drops.
Yes. So there were blood drops located in this area.
And were there more blood drops?
There were more blood drops.
Okay.
This is the area which I was describing earlier. There were blood drops leading up to where Dominic was eventually found.
You also testified to a shoe by Griselda's body, correct?
Yes.
You said the other one was the right shoe and this was the left shoe?
This was the left shoe, size 8. And this is where I first encountered Burgos, or where I first saw him.
You indicated that a stroller was also found?
Yes.
Put that where the stroller was. And finally, as lead investigator, you said you saw the baby of the infant.
Yes, I did.
What was that? All right, you can have this. I think right now I'll move to resubmit State's Exhibit 105.
Any objection?
No objections, Your Honor.
State 105 is admitted.
Were you able to ascertain what Mr. Burgos' actions were when he found the body?
Yes.
And what was that?
I learned that he was
All right,
touching
yes,
certain
all right,
items.
all right. Yes.
Objection is to interpretation of the requirement.
All right, approach. Same.
Now, as part of being the lead investigator, did you video or have the crime scene video?
Yes, I did.
And what's the purpose of the video?
To document how the crime scene was found.
I approach on. I'm gonna show you what's been previously.
Yes, I am.
Okay, you had the opportunity to keep the viewers.
Yes.
And the crime scene video that you directed is on your head.
Yes.
This has already been admitted. Our permission to publish the video of the crime scene. Now, if you could narrate what it is that you're seeing.
Well, right now, we're seeing the Border Patrol trucks as they work when I arrived. This was identified as Bradley Denison's unit. Unit Kilo 66119 was identified as assigned to Ronald Anthony Burgos.
And this video was taken at the time of the investigation that morning.
Correct, on April 9th.
Pause. This video is the crime scene, Your Honor. I forgot to mention, just for purposes of sensitivity. But
Go ahead.
Before we bring the jury in, just this state is rested. Before we open our case, we would like to make for the record, a motion for a directed verdict of acquittal.
Go ahead.
For the court to rule upon. Judge, we do not believe the state has met their prima facie burden of proof.
Very good. Your motion is with regard to all counts.
Yes, sir.
Okay. Your motion is denied.
Thank you.
Okay, let's bring the jury in. Well, the defendant's already here, so we can bring the jury in. All right. And let's get Dr. Stern is ready to come in at a moment's notice. Yes,
she's in the room.
she's ready. Okay.
You rise for the jury.
Thanks, everybody. Please have a seat. Mr. Peña, as you know, the state has rested. Do you intend to call any witnesses? Dr. Corinne Stern? Yeah, just over abundance of caution. Now, I believe that you have been sworn in, but since I released you, I'm going to swear you in one more time.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please come around here, the witness chair. Or lower the mic a little bit if you'd like. Thank you. Mr. Boggs, you'll be doing the examination.
Yes, sir.
Thank you. You may begin.
Good afternoon, ma'am.
Good afternoon.
Thank you for being here.
Sure.
Ma'am, just so everyone, well, let me start. We did not meet last week. My name is William Boggs. Thank you for your patience. You testified last week as an expert for the district attorney. Is
Yes,
that
sir.
correct?
Yes, sir.
Yes. And I just I want everyone to understand your qualifications.
Sure.
And your educational background.
Absolutely.
And that was something about which you testified last week,
Okay.
correct?
Yes, sir. I did.
And ma'am, you do not hold a MD license, is that correct?
No, not an MD.
Okay. You are a doctor of osteopathic medicine. Is that correct?
Osteopathic medicine. Yes, sir.
And could you explain to us what the difference between a MD and a osteopathic doctor means?
Absolutely. So an MD, we call that allopathic medicine, and a DO we call osteopathic medicine. And it's just the type of training during the 4 years of medical school. It's osteopathic medicine is just a little different way of looking at medicine. So we use a more holistic approach, not as in holistic medicine, but in a holistic approach to the body, as in structure affects function. So in other words, we don't want to just treat the symptoms. We want to get to the cause of the symptoms and treat that. So there's a few more courses we take. We go all our summers. We take classes in osteopathic manipulative medicine, sports medicine, and other things that function on looking at the body as a whole, if you will. It's just a different method of teaching while in medical school.
And so, ma'am, you indicated that osteopathic medicine deals with the entire body, correct?
Well, yes.
So, for instance, the American Association of Osteopathy strongly recommends yoga, for instance, correct, ma'am? Is that
Not when I was in yoga, wasn't a thing when I was in medical school, but they may now. I don't know.
So, for instance, if you visit the American Association of Osteopathy website today, they will recommend yoga. And I'd say we're all big fans of yoga. Okay, so this is no impugning of yoga, but that is an example of the approach of osteopathy.
Oh, I believe it because we put a big emphasis on staying physically healthy. So I can understand that they would be promoting yoga. Yoga was just not a popular thing when I was in school way back when.
And you, on direct examination with Mr. Alanese, indicated that you do forensic pathology. Is that correct?
That's correct.
Okay. Now, are you a board certified pathologist, ma'am?
No, I am not.
Okay. And you remember being asked, because you indicated I apologize, let me back up a little bit. On direct examination, you were asked by Mr. Alanese about your qualifications.
Yes.
You recall that? And you said that Mr. Alanese asked, and I'm looking at page 146 of the draft transcript, which is okay, can you tell us a little bit about your education background and your training that qualifies you in this field as a medical examiner? And you answered, sure. I received my undergraduate degree in medical technology from the University of Mary Hardin Baylor in Belton. I graduated from medical school at the University of North Texas Health Science Center in Fort Worth. I have a master's degree in public health. I went to medical school at the university, did that, did my residency at the University of Hawaii at Manoa and Honolulu. I then did a surgical pathology fellowship at the University of Texas Health Science Center in San Antonio, and I did my forensic medicine fellowship with the Office of the Armed Forces Medical Examiner in Washington, D.C. I'm licensed to practice medicine in the state of Texas. I passed my forensic boards in 2001. I'm a member of the National Association of Medical Examiners and the American Academy of Forensic Sciences. You remember that question
Yes.
and that answer, ma'am?
Yes.
So when you said I passed my forensic boards in 2001, you did not mean as a board certified pathologist.
No.
Is that correct?
Just my forensic board exam. That's correct.
So now you were asked by Mr. Pena on cross-examination.
I'm gonna object at this point in time because now she has, it's
All right,
improper.
Let me do it this way. I think you should approach, please.
Ma'am, doctor, you remember being asked by Mr. Pena what you meant by passing your boards. Do you remember that, ma'am?
I don't remember that question. I remember him asking me the organization that those boards were under.
Okay. And you remember referring to the American Board of Pathology.
That's correct.
Okay. So when you were asked what it meant to pass your boards, last week you said the American Board of Pathology. Am I understanding you correctly?
That's not the question he asked me.
Okay. Ma'am, were you asked the following question? Did you give the following answer? Okay, doctor, you mentioned that you passed your boards. What exactly were you referring to? And your answer, the American Academy of Furin, the American Academy, the American Board of Pathology, my forensic medicine boards given by the American Board of Pathology. Do you remember being asked that question and giving that answer?
Well, I remember him asking me what the organization was. I can't remember word for word exactly. I remember him asking me what the organization was, and I remember telling him I did pass my forensic medicine board.
And would it refresh your recollection to see a copy of your testimony, ma'am?
No, I'm answering you what I remember telling him,
Okay.
which is the same thing. I don't know how else to answer this.
Okay, so last week, and I just want this for the record to be clear, when you were asked by Mr. Pena, right, what you were referring to when you said, I passed my boards, you listed the American Board of Pathology. Did you not, ma'am?
When he asked me what the organization was, yes.
Okay. And so, but today you're telling us you are not a board certified member of the American Board of Pathology, correct?
I never said I was, and
So when Mr. Pena asked you what the organizations were, you listed American Board of Pathology, though, correct?
yes, that's where I took the exam.
But you're not a board certified member of the American Board of Pathology.
No, I am not a board member certified of them, but I did pass my forensic medicine board exam.
And ma'am, in fact, back in 2009, so some 14 years ago, you were one of only 2 medical examiners in all of Texas that were not a board certified member of the American Board of Pathology, correct?
Oh, I have no idea.
That's complete speculation on her part as to who.
Well, she can answer.
I have no idea.
Okay. Well, in fact, you were contacted by Channel 5 Dallas NBC News for a comment on your lack of qualifications, correct?
I'm going to object to the relevancy of this question, and he is harassing the witnesses.
I'm over.
I have no idea. I do not remember that. Absolutely not.
And you declined to comment, correct?
I have no idea. I do not remember that at all, Judge.
And the
no recollection.
Whatever you remember.
Okay.
And the other medical examiner who was not board certified in El Paso said he was going to seek his board certification.
That question improper hearsay.
The witness is testifying as an expert, Your Honor. She's allowed to give her opinion.
He's testifying from counsel's table, Your Honor.
Just rephrase your question.
I can move on, Judge. Ma'am, last week there was a discussion about your experience in Alabama, correct? You remember that?
Yes.
And you wish you never left Texas. Is that correct, ma'am?
That's correct.
My memory? Okay. And you'd had a poor experience in Alabama where you were the state medical examiner for the Department of Forensic Science, correct?
I'm going to object. This has already been asked and answered and they cross-examined on this topic, Your Honor. It's been thoroughly.
I think I understand what you're saying. I think that they have the opportunity to call her as a witness on their side if they'd like. They're doing that now. I don't think I can limit that situation. Overall.
And the very organization that you were the head of disputed your findings in a death penalty case. Isn't that correct, ma'am?
Yes, after I left.
And last week you indicated it was because of defense experts. Do you recall that, ma'am?
Yes, that's
But
what I believe.
It was
Yes,
actually the district attorney who dismissed that case. Isn't that correct?
that's correct.
That was already asked and answered last week.
And ma'am, you said that was after you already left. In fact, you sued the Alabama Department of Forensics Science after you left. Isn't that correct?
Object again, it's just badgering and try to attack her character, Your Honor, has nothing to do with the qualifications. Way outside the scope.
I understand. Overall, though.
Yes, that's not correct. That was before I left.
You sued them before you left.
Yes.
Okay. Judge, if I could have just one moment to confer with counsel. For your patience, and I can have a combative manner. I apologize.
You're fine. Thank you.
I pass the witness.
Any questions?
Hello, Dr. Stern. Let's back up here a little bit and talk and explain to the jury what board examinations and certifications you have. If you
Oh,
can.
okay. So I am a diplomat of the National Board of Osteopathic Medical Examiners. I don't remember the year. I did pass my forensic medicine board exam given by the American Board of Pathology. I believe that was in 2001. I'm licensed to practice in the state of Texas. I am a fellow of the National Association of Medical Examiners, and I'm a member of the American Academy of Forensic Sciences in the biology section.
This other question that they're making a big deal about, which is the being a diplomat.
Objection to the form of the question, Your Honor.
You open the door, Your Honor.
This thing, just rephrase this thing.
That you're not a diplomat of is it the American?
That's the American Board of Pathology.
Okay. Is that required for the job you do?
Oh, absolutely not.
Are you a diplomat of any of the boards, any other association?
Well, the National Board of Osteopathic Medical Examiners. I am a diplomat.
Okay, and what are the requirements to become a diplomat?
Oh, well, it's a 3-part exam, and you must pass all 3 parts. And I passed all 3 parts.
Your American Board of Pathology, when did you pass that exam?
In 2001.
Okay, is that a specialty exam?
Yes, that's a subspecialty exam. Yes,
Okay. And when you say my boards, what does that mean, my boards?
it's an exam. It's an exam given by an organization called a board.
Okay.
It is a board exam.
Are you familiar with the section under the Code of Criminal Procedure that regulates the medical examiners?
Oh, yes, sir.
And what chapter is that?
49.25 of the Texas Code of Criminal Procedures.
And do you meet all the requirements under that section to do your job?
Meet and exceed. Yes, I do.
And how long have you been a medical examiner?
Well over 20 years.
And let me ask you, doctor, is it uncommon that your findings or opinions are contested or that other pathologists in your field may disagree with findings of other pathologists?
No, that happens in every single trial. You know, the prosecution has a witness, and in a civil trial, the plaintiff has a witness, and then the defense attorneys, they have their witnesses with their opinions. That's what being an expert is all about. We're always questioned. We're always questioned.
Okay. Can I approach the witness?
You may.
I'm going to show you what I'm marking as State's Exhibit 533. And I would like for you Go. You're familiar with 533?
Yes, this is a copy of my CV.
Okay. All right. And I'm going to ask you if you can go over the section of publications.
Oh, okay.
What is that?
So these are articles in peer-reviewed journals that I've written or co-authored.
Okay. Before you testify from that, Your Honor, I'd like to introduce State's Exhibit 533. I believe they have a copy of it.
The objection to 533.
Objection, Your Honor.
Admitted. When this section says publications, what does that mean?
So these are articles in journals, peer-reviewed journals.
By whom?
So you write an article, I did the research, I wrote the article, and then it's there's on every journal there's a list of editors or reviewers, and they have to review the articles and decide if it's worthy enough to be published. They check your research and things like that.
And these are articles you wrote?
Yes.
What was the first article that you had listed here?
Unauthorized border crossing and migrant deaths in Arizona, New Mexico, and El Paso, Texas. I wrote that with individuals from the Center for Disease Control and Prevention.
What's the next one you wrote?
This was mass fatalities and role of the medical examiner. This is a local journal by the El Paso, I don't know the exact title, but maybe Physicians Association in their local journal.
What is the next article that you published?
That was an antiphospholipid syndrome that has to do with your blood clotting. That was published in Laboratory Medicine.
What about the next one?
Warfarin-induced elevation of the activated partial thromboplastin time. It also has to do with blood clotting. This was an area I was interested in early on. Cervical vaginal cytology in women treated with tamoxifen for breast carcinoma. I did some research to determine if women who use tamoxifen, which is a drug we use to treat breast cancer, was making any difference in their pap smears.
Now, you're also a presenter. Have you had the experience of being a presenter?
Yes.
Okay. Can you tell the ladies and gentlemen of the jury some of the presentations and topics that you made?
Yes. Let me just preface it by saying there's been probably a dozen since this. But I do quite a few crossing through the borderland. I do quite a few presentations around the country on border crossing fatalities. Myself and my office are subject matter experts on that, just because we see so much of that. So that's a presentation I did at the American Academy of Forensic Sciences. I've presented twice at the Border Patrol symposiums. One was in Arizona. I can't quite remember where the other one was. I've presented at the binational conference between Mexico and the United States on this topic as well.
What about this presentation?
Blood and body fluid precautions with DMORT, that's the Disaster Mortuary Operational Response Team. That is a division of the National Disaster Medical System. I do serve on that team, and I've presented several times at our conferences.
What about the next one?
Crossing deaths in Webb County, again, dealing with our border crossing deaths. The death certificate dilemma. This was presented here at the Laredo Medical Society, but and I've presented that as recent as last year, so multiple times. Also, the state of Texas has me lecture on this to the incoming justices of the peace. They have me on a cycle, I think, every other year. I'm a presenter to teach the JPs on how to properly fill out a death certificate.
What about this one?
The role of the medical examiner in mass fatality incidents. I presented that in Washington, D.C. my master's degree is in public health. It has a concentration in mass fatality management. Disaster mortuary operational response team, standard operating procedures, again, teaching teammates across the country of our policy and procedures. A case of death due to an air emboli in a male. This was a case study I had. It was actually a case out of Alabama. I presented at the American Academy of Forensic Sciences. It was selected to be presented. Sudden unexpected death in infancy investigation, SUDI. We're now getting away from the term SID, sudden infant death syndrome. We now use sudden unexpected infant death or sudden unexpected death in infancy. That's what that mnemonic is for. And I did present at the Centers for Disease Control and Prevention in Atlanta on this topic.
Okay, we'll take it from the top over here.
Forensic pathology and lessons learned in the wake of Hurricane Katrina. I do serve as a forensic pathologist with the Disaster Mortuary Operational Response Team, and I was deployed to Hurricane Katrina. I spent 7 weeks there. I set up the portable morgue unit and worked. And this was a presentation I was asked to give afterwards with my experience there. Mass fatalities and the role of the medical examiner. Again, that's one of my specialties. I presented that at the State Coroners Association meeting in Alabama. Pediatric autopsy, I was asked to present at the National Child Abuse Symposium. I was approached and asked to present and put a presentation together about the best approaches for a pediatric autopsy, so autopsies in infants and children.
That was also in Alabama.
Yes.
Okay. Next one.
Lightning strike fatality in a hunter. This is also a case I had in Alabama. It was selected to be presented again at the American Academy of Forensic Sciences, and I presented it. The forensic pathologist and the role of radiology. I was approached one day, got a phone call from a radiologist with the Mississippi State Association of Radiology Technologists. She had seen a prior presentation and asked me if I would put something together explaining the role of radiology or the role of x-rays in forensic pathology. And I did travel to Mississippi to make that presentation. Texas death certificate and the role of the physician. Again, this is with the Texas Bureau of Vital Statistics. I currently still make that presentation. I'm kind of on a rotating schedule, and about every other year they do call me to make that presentation to the justices of the peace. 9/11 and the role of the forensic pathologist. This was one of the binational conferences with Mexico. I did serve at 9/11. I was actually deployed the night of 9/11 and served in New York. And this, I was asked again afterwards to present some of my experiences as a forensic pathologist on the ground there. Dying to be thin. This was a case presentation on a patient I had that died from bulimia and anorexia nervosa. It was selected to be presented at the National Association of Medical Examiners annual meeting, and that was a poster presentation. Aerospace pathology. I was asked to make that presentation with DMORT. My specialty where I trained with Office of the Armed Forces Medical Examiner is aerospace pathology. Fatal cardiac sarcoidosis in a patient previously diagnosed with Chagas disease. Chagas disease is caused by a trypanosome. This was a case that I had when I was in El Paso. It was selected to be presented at the NAME meeting, National Association of Medical Examiners, and it was a poster presentation. I was a panelist. This was a mass disaster response. This was a conference across the border I was invited to in Mexico, and I was a panelist answering questions related to trauma as seen by a forensic pathologist. Sudden and unexpected deaths from seizure disorders, a retro and prospective analysis. This was my subject of research when I was a resident in pathology, and I presented some findings at the American Academy of Forensic Sciences. Texas Society of Pathology, I was a poster presenter. This was actually a poster on interdigitating dendritic cell carcinoma. I had presented it at a meeting in a lecture type presentation, and then at the Texas Society of Pathology, I had a poster presentation of it. Same one, interdigitating dendritic cell carcinoma. Cervical vaginal cytology in women being treated with tamoxifen for breast cancer. Again, I was asked, this was a clinical research symposium I presented to, actually won first place. American College of Clinical Pathology, College of American Pathologists. I was a poster presenter. 97, that would have been with my tamoxifen study. Residence form. When I was a resident and also a fellow, I was our resident delegate, and I presented, I guess, the role of the physician assistants in pathology training programs. These were just presentations I was asked to give. The next one, the role of the pathologist as a vital member of the healthcare team. These were presentations I gave as a resident. Purpose of the nominating committee. These were actually resolutions where we were actually trying to change some laws within our organizations. And so I presented on them.
What were some of your honors and awards?
Oh, Golden Key International Honor Society. That was based on grades, I'm sure. Delta Epsilon Tau Honor Society. I think that was during my master's degree. I'm not exactly sure, but again, it was a grade based. I was on the president and dean's list when I was at the university. NDMS, gave me the 2008 Distinguished Team Member Award. That's from the Disaster Mortuary Operational Response Team for my service through the years. The 2005 American Red Cross Hero of the Past, I was nominated for this award along with several other physicians, and I was actually picked to receive it based on, I call it an act of heroism. I was given it, it was based on my work with organ and tissue donation and recovery.
Mr. Alanis.
Yes.
The document's already in evidence. You wish to go through the rest of her
I just
college
have a few.
accolades and
I
others?
have 5 more honors and awards, Your Honor, and I'll
But-
finish up with that.
Is there a story to tell on each one of them, or,
What her explanation on each one?
I mean, you went over the dean's list?
Yes. Well, I just needed to just finish these last 4. Go ahead.
Okay, AFIP Fellows Symposium Original Manuscript, 3rd place. That was on research that I did when I was at the Office of the Armed Forces Medical Examiner. Calendar Binford Scholarship. I received a scholarship to do my forensic medicine fellowship. That was typically only open to members of the armed forces, and I received a scholarship to do one as a civilian. 1st place residence paper competition. That was on my my research with epilepsy and seizure disorders. Again, the Dean's Research Award on the same topic. And then Who's Who in American Colleges and Universities. My medical school nominated me for that.
Do your qualifications comply with the Texas Code of Criminal Procedure?
Yes, sir.
Are you currently conducting, or when was your most recent research project or anything current going on?
Still working with the border crossers with numbers and still developing policies, the best practice policies and procedures.
Now, you weren't the medical examiner that performed the autopsies in this case, correct?
No, sir.
But you did testify last week as to an opinion as to the injury on baby Dominic's leg, correct?
That's correct.
And do you still stand by that opinion?
100%.
And in your opinion, was it caused by a spider or insect bite?
No, it was not.
And what was your opinion as to what caused that injury?
This was a puncture wound. It was a deep puncture wound. In my opinion, it was caused by a large bore needle. That was most consistent with the injury that I saw.
Thank you, Dr. Stern.
That's
it.
You've received a lot of awards. Is that what we're to understand, Doctor?
Yes.
Okay, but I'd really like to talk about your testimony here last week, because today, as I understand, you're saying that you were not certified by the American Board of Pathology. You only passed the exam in 2001. Is that correct?
That's correct.
All right. You remember being asked by Mr. Pena when you were certified by the American Board of Pathology, and your answer being it was in 2001?
No, he never asked me about certification.
So, ma'am, were you asked the following question, the following answer? Question, I see. So, and what day did you get certified? Answer, it was in 2001. You didn't?
I don't remember that question. I don't.
Would it refresh your recollection to see a transcript of your testimony?
Well, I believe what you're telling me.
Well, ma'am, I apologize. That's very kind. But would it refresh your recollection to see?
I don't think it's going to make me remember him using the word certification.
So I just want to make sure the record is clear. You're denying that you were asked that question, or you do not recall whether you were asked that question?
I do not recall that question.
And you're saying it would not refresh your recollection?
Well, I can see it, but I don't independently recollect being asked that question.
Now, on the state's examination just now by Mr. Alanese, he indicated, and he specifically pointed out some conferences that you presented at in Alabama, correct?
Yes.
Okay, and that was in 2006, correct?
I think most of them were in 2006.
Now, all of those conferences were before the November 2006 Alabama case that we have discussed here in court, correct?
I don't know. I don't know that, but.
So once you left, for instance, the Alabama Forensic Commission, you were no longer presenting in Alabama on, for instance, pediatric autopsies.
No,
correct?
I was no longer presenting in Alabama.
And in fact, all those conferences that Mr. Alanese went through, right, pediatric autopsies, you didn't present on them anywhere, not just in Alabama, correct?
I'm sorry, what is your question?
You presented in Alabama in 2006 on pediatric autopsies.
Yes.
Okay. And you said you no longer presented in Alabama on pediatric autopsies. But the truth is, according to your resume, you didn't present on pediatric autopsies in any jurisdiction. Is that correct?
I guess I still don't understand your question. Alabama is a jurisdiction. I presented there.
After November of 2006.
Have I presented?
On pediatric autopsies in any jurisdiction?
Yeah, I believe I have. They're not on that. They're not on that CV there, but yes, I've presented at JP conferences on pediatrics. I have.
Okay. On pediatric autopsies, ma'am?
Well, yes, that's what I do. Autopsies. Yes.
But it's not in your resume. Or
No,
your
it's not in that resume. There are probably many, many more presentations that I haven't listed. That's the resume gets 6, 7, 8 pages. It's, You know, I put some pertinent things on there and,
Judge, if I could just have one moment, I apologize. For your patience, ma'am.
Sure.
I've passed the.
Anything else?
No, Your Honor. Thank you. You are now re-released. You may go about your business, man. Thank you. Thank you for making time for you.
Thank you.
533 was, yes, it was admitted. Thank you. Thank you, Doc.
Mr. Peña,
Yes, Your Honor.
do you have any other witnesses?
No further witnesses, Your Honor, just some medical records that we would like to review.
Very good. Thank you.
Judge, at this time, we would move to admit under the business records exception what's been provided to the district attorney. Defendant's Exhibit 7, which is a self-authenticating document put out by Dania Cortines, dated March 29th of 23. It's 105 pages.
Defendant 7, any objection?
May we approach?
Defendant 7, it'll be admitted.
Judge, at this time, I'd like to publish, the document is 105 pages in total. We just have 5 pages to publish to the jury.
Go ahead. This document has been introduced and admitted into evidence. There has been a request to publish a certain number of pages of that document,
I don't need to see him, that's okay.
and Mr. Boggs will do that right now.
For the record, this is page 29 of 105. Judge, I've changed the page. This is now page 44 of 105.
Go ahead. Mr. Serrano.
For the record, I'm publishing, putting on the projector, page 47. changing to page 60, 105. I'm now changing to page 70 of 105. And for this exhibit, Judge, that is all correct the pages and
Defendant 7 then has been admitted.
We have one other matter about which we would ask the court to approach as well.
You would what?
Ask to approach the court.
Approach, please.
The judge did warn that that we were going to be riddled with sidebars before he brought in the jury. So, oh boy, I really had hoped we'd start having the defense. Oh, we're still not done. Got our hopes up for nothing. I've just been trolling for news stories over on YouTube. Used to be able to get news stories more in my YouTube feed, but they seem to have changed how things go. So, let's see. Maybe you look at Twitter instead. Nope, that's not Twitter. That's Facebook. Oops, let's see. Let's get the right tab here. Oh, we've got a man who's handcuffed himself to the gates of Buckingham Palace. Police have evacuated the surrounding area and are now negotiating with the individual. Okay. According to Taz says, seriously, taser the Muppet, get some bolt cutters, handcuff him whilst he's still down, arrest. Our police are the laughingstock of the world. Maybe they should form a line around him and do the Macarena while somebody films it for TikTok. Oh dear. There's been a lot of talk today about a guy who killed his Spanish teacher getting sentenced today. Doesn't say what his sentence is though. Okay. We'll share this funny thing that somebody posted on Twitter here of El Presidente. So, oh dear. So, gotta make fun or you're gonna cry. Let's see. Is there anything else? Indiana, that one doing the handcuffing himself to Buckingham Palace. Excuse me, nobody's actually living there right now. They're renovating. Okay, back to Twitter, see if there's anything.
What is this, if any? All right, so the defendants have rested.
What? What? They rested?
I understand, I want to put this on record that you had, Mr. Pena and Mr. Boggs, your defense team had opportunity prior to making that decision to rest, to speak to your client. Is that correct?
That's insane.
Very good. Throughout the entire trial, you've had the opportunity to do that. Is that correct? And the decision, obviously, could you approach? I'm sorry.
Okay, I think we're having a major sidebar here. I can't believe they aren't presenting any defense whatsoever. That is insane. I mean, this is a death penalty case. And if that's the case, then I think we'll probably be resting. I mean, we'll be adjourning, and I don't know if they would be doing jury instruction conference tomorrow and possibly close. I don't know if they could do closing arguments tomorrow or not. Wow, I didn't see that coming. Whoa. I mean, I thought we'd have at least a week with the defense presenting. They must really be thinking that the people over on Law and Crime, when I was looking, they were saying they have no defense. That's why they're postponing, and so it turns out there is no defense. Why didn't he just plead guilty in the first place and save all this trouble? He could have done it years ago. Wow. I think the judge is going, "Are you sure about this? This is and yeah, this is, I wonder if this is some ploy of the defendants to get ineffective assistance of counsel, getting the trial overturned on that basis." But wow. Shocker here. Wow.
Do you close Or do you close or do you have rebuttal?
We have one rebuttal, Gabriela Rebollado, Laredo Police Department. She's got, yes, well, I'll label it. It's just to introduce, this one, what would be the next exhibit?
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
If the defense rested, who are they calling?
Gabriela Rebollado.
And what is your job?
I am currently employed with the Laredo Police Department as an evidence custodian.
Oh, so this would be
I've been with the Laredo Police
Rebuttal?
Department for 14 years.
You're a licensed police officer?
Yes, I am, sir.
And what's your current assignments and duties?
My current assignments for the past 3.5 years have been assigned to the property and evidence section.
My approach? Yes. I'm gonna show you what's in Mark Street's exhibit 534. Ask if you recognize this.
Yes, sir.
Okay. And I'm gonna move to introduce offer states exhibit 534.
534? No objection, Your Honor. Admitted.
Okay, and this, what's the contents of this? You know? Check it.
The contents is a one fabric black in color satchel, quotation Live Strong Austin Marathon and Half Marathon. One pair of Nike tennis shoes.
And this was, where is this, what case is this from?
This is from case number 1800-8810.
Is that the same case of the state of Texas versus Ronald Anthony Bugos-Aviles?
Yes, sir, it is.
No further questions. Any questions? No questions, Your Honor. Do you close? I'm sorry. You make that.
Thank you.
State closes, Your Honor.
Do you close? Ladies and gentlemen of the jury, you have received all of the evidence that you are receiving in this case. I'm about to send you in to the jury room, not the deliberation room yet, just the jury room right now. It will change hats here in a moment. Where I am going to discuss a couple of things here with, shouldn't take very long at all, because we have already discussed them ahead of time. And then I'll bring you back in to read you the instructions and you can hear argument from counsel. If you all want to make some calls, let them know that you'll probably be getting home a little bit later than normal, and you may do so as well. I can't tell you obviously how long that would be, but so we'll go ahead and allow you to use your phones to be able to get that done. All right. Thank you.
You drive by the jury?
I'm going to guess that the defense thinks that the bit on having the medical examiner on the stand and questioning her credentials is sufficient to have the whole the jury rule that the whole thing is not guilty because it's reasonable.
I need that document now because we're going to talk about it like this moment. So maybe you can go in and just get that. I'm going to get that printed. You all should already have, or you should send them a copy of it, the one you worked on here at the very last moment. Check out the changes, and then we'll make the whatever other announcements with regard to the charge there. All right, thank you. We'll be right back.
Um, I'm flummoxed because of this. Um, the only thing I can, she testified that she thought that it was an injection and not a bug bite. She didn't do the autopsy, they were saying. So I understand it. She was just testifying about the opinion on the bug bite not being a bug bite but being an injection site. And so if that's the case, okay, so maybe that would cast into doubt whether or not Dominic, he had attempted to kill Dominic previously, but they are pretty much, not refuting the fact that they were murdered. And it really looks like dear old Daddy Dearest was the killer. And he, I'm sorry, but casting doubt on whether or not an injection took place or not 2 months prior to the murder doesn't mean the murders didn't take place. And, it seems to me that it's a huge trying to go for the ineffective assistance of counsel right. But if this is done with his blessing, I don't know. I just can't see him getting a new trial because, oh, we didn't like how the prosecution case went, so we want a do-over. And, we'll see how it goes the next time around. And if that one doesn't go right, then we'll say ineffective assistance of counsel again. Let's take a look and see what some of the comments are going. Oh, I want to see some legal commentary on this, because I'm just kind of mind blown by this. Oh, I think my video may have finished being edited. Let me take a look. Yay! It likes the video better now. I must have cut like 55 minutes of dead time while we were waiting. Okay, well that works. Keeps YouTube happy. Okay, so let's go back to what we were watching earlier while we're waiting. So let's...
Making that announcement. This goes along with the instructions that I gave with regard to the other matter to gallery, media, and whatnot. Thank you. Go ahead.
So this video does show graphic images, correct?
Yes, it does.
So the first thing that narrate what we're seeing.
We're seeing, I don't know if you see these marks. Those are the stroller marks. Of course, this is a body of Grizelda Hernandez as she was found. She was very bloody. That is the left white shoe. You can see the stroller marks.
Next video is 478.12. That was 478.11. Now we'll play 478.12. If you could tell us
what we saw earlier with the blood droplets that I was talking about. Again, it's Griselda. There's the dirt on her back that I was observing at the time. These electrode pads are from the paramedics who checked for her vitals.
were you able to observe the type of injuries she had or describe the injuries that
Yes, I was. Once the medical examiner came in, we were able to examine her closer. And yes, she had several sharp force injuries.
How far did the blood trail go down that dirt path?
The blood trail went down that dirt path approximately, I would say, 20 to 25 yards. And I only say that because it led to Dominic, and Dominic was approximately 20 to 25 yards from where Griselda was located.
.13.
That's another view of where Griselda was located. And that direction is south.
What is that?
Those are the tire marks. The vehicle tire marks. That's the blood droplets that I described earlier.
What is that? Notice are there
Yes, so there's several shoe prints.
what is that at the top of the screen?
That is the stroller marks where it ended.
What's that on the floor? An item on the floor that you see that object on the floor?
Which object? I don't know.
That
Oh, it's a branch.
the broken branch?
I'm not sure. I don't recall.
what is this here?
That is the stroller.
Where would the baby's body be in relation to what we're seeing here?
In relation to what we're seeing, the baby would be across the trail on this side. Sorry.
48.14, 478, 478.14.
Approach these spots.
We're seeing the body of Dominic.
What are we seeing?
We're seeing the body of Dominic, bloody clothing. You could see an injury on his neck, bloody jeans. And also something that I noticed, the earth. I'm sorry, the earth around. I'm sorry, the grass around Dominic is disturbed. It's pressed down.
Hmm.
Now, the items that were at the crime scene, were those collected?
Yes, they were.
I'm not sure you state's exhibit, my approach on. I'm gonna show you state's exhibit 22. You recognize this?
Yes. Yes, I do.
Introduce States Exhibit 22, Your Honor. If you can tell the ladies and gentlemen of the jury to stand up and show this to them.
This is Griselda's shirt that she was wearing. So, bloody shirt.
I'm going to show you States Exhibit 21.
Sorry, more other groups?
Yeah, you're gonna
I'm sorry. I just didn't want to press.
look at that and ask me if you.
Those are the blue jeans, bloody blue jeans. Sir.
Admit these States Exhibit 21 may be an under chain of custody.
Okay.
I'm going to show you what's labeled as States Exhibit 21.
Yes.
And what are you holding in your hand?
These are Griselda's jeans that she was wearing when she was found.
What is it covered?
Blood,
What else?
dirt.
Show you States Exhibit 38. Ask you if you recognize this.
Yes, I do.
This is 38. Move to introduce States Exhibit 38 from.
Admitted.
What is States Exhibit 38?
It's the right shoe.
And where
That-
was the shoe found?
This was found in the brush south of where Dominic was located.
And where was the other shoe found?
The left shoe was found by Griselda.
I'm gonna ask you, keep your gloves on. Have a seat. Were you, as the lead detective, also involved with, you have a seat, with the search of the kilo unit, correct?
Yes.
And what, if any, items did you find in the kilo unit?
In the kilo unit, we found a crumpled up written voluntary statement. Found a bloody belt keeper. We found 2 phones that we later found that belonged to Griselda and baby Dominic. We found syringe. We found needle. We found blood flakes. We found blood drop and blood smear on the tailgate of the kilo unit.
Okay, let's go one by one. I'm gonna show you, and mark this, States Exhibit number 6, States Exhibit number 15. Ask if you can recognize. States Exhibit 15. Yes, I do. Okay. I'm gonna offer 6 and 15.
Look at it.
Yeah, you can look in 6, tell us what that is.
This is the underbelt that Burgos was wearing at the time of his detention.
I'm gonna show you States Exhibit 32.
Yes, I do.
Now, Mr. You can have a seat. Mr. Burgos was on duty when you first came in contact with him,
Yes, he was.
and can you describe what he was wearing as part of his uniform?
Yes, he was wearing the Border Patrol uniform along with his utility belt. Utility belt is the belt that carries the equipment for a law enforcement officer to include, his handgun, magazines, taser, baton.
And he had that on,
He had that on.
and that was seized and recognized as States Exhibit 6.
Yes.
Take one step down to show to the jury.
That's what.
Now, explain to the jury when you said he was on duty at the time. Where does that sand brown of this utility belt go? How is it secured to the belt?
It would be secured by belt keepers. So this is just the belt keepers are used to fasten the utility belt to the underbelt, preventing it from, shifting during, toward duty.
How is that put on? So how is it wrapped on?
Yes. So you would strap it on like this, buckle it, and then you would fasten your belt keepers to the belt.
You also said you discovered a crumpled up statement.
Yes.
This was in the truck.
Yes.
This is States Exhibit 32. And if you could read for us what he wrote in this. Read at the top. What does this document say it is?
It says it's It says it's Laredo Police Department voluntary statement form.
Okay. And who's the author?
Ronald A. Burgos.
Okay. And you know this address, 1119 McPherson Avenue?
Yes, that should be the address for the Laredo Police. I'm sorry, Laredo, the U.S. Border Patrol station.
And he's writing this in the capacity of a USVP,
Yes,
United States Border Patrol.
United States Border Patrol, USVP,
In what capacity?
as a supervisor.
Okay. And is it in his capacity as a supervisor, what is his statement in reference to?
It's in reference to the discovery of.
Well, read what it says.
Okay.
I'd like for you all to take a look at the chart that I have, that we prepared after much conversation and argument on the charge that the court is inclined to read to the jury. I understand that the objections that have been made have already been made on the record, and I'll carry the same objections to the question that I have now. Any additional, in fact, I think there were only three. Did you include the paragraph that, or the provision that was asked for? And it was a paragraph 7, is that correct?
Yes,
All right,
Your Honor.
I see it there, yeah. All right, so the state had asked to change the 2 counts at the very beginning. The state had also asked whether or not the word unanimous should stay there. It stayed. And then the state had asked to keep an instruction on paragraph 3. That stayed. I know there was an objection to it, and it continues to be. It's the same ruling on paragraph 3 of the proposed charge. And I believe that there was a request to include new language and to make it paragraph 7 of the charge. And in fact, I see that has already, wait, would that be paragraph 8? Nope, I see that paragraph 7 has now been included in the charge. And anything else? So they don't have a copy? Yeah, they do, no? Did y'all get a copy of the last one? Okay. Yeah, I better give you that. Thank you. It should be exactly the same thing you sent, Alma. We haven't changed it. All right. From the state side, any objections to the charge of the court? From the defense side, any objections to the charge of the court other than the ones already posed?
Just want to point out the paragraph where we need 7. There are a couple, just so that when the court reads this, doesn't stumble over this. And I think they should just try to grab
Thank you.
things. So in the 3rd paragraph, it says in oral record statement, and I believe it should be an oral recorded statement by a defendant. I think that might be a typographical error.
Just for the record, you all typed this one out, right?
I agree.
Yeah.
It was typed up just a few moments ago, right? And there's a second one on page 5 with the first full paragraph at the top. If you do not find that state, I should say, if you do not find that the state has proved these things.
Thank you.
And those are the 2 typographical things.
I have, I'm going to read it as the way that you have just suggested that I do, so I don't stumble with my words. And I appreciate you telling me that. Thank you. And in fact, the original one is the one that I have here. The rest will be a working copy for both you all and the rest of the jurors. Other than that, anything else, Mr. Peña?
Nothing else, Your Honor.
No further objections, no further inclusions. Is that correct?
That is correct, Your Honor.
Very good. Oh, you know what I don't have here? The verdict form.
That one did not change.
Your Honor, I believe we did add unanimous to the verdict form as well, but that was provided to the state last night and we made no revisions today.
I don't think that one was sent to me. Can you send it to me? No? Well, let me see. There's a verdict form that I have that says verdict of the jury defense revised, but that one was sent to me way back then. That was not it. Can you tell me where?
Yes, Your Honor, if the rules have been provided, then
I have it here. I don't know if you can see it. Okay. And that was it, right? Hopefully.
You're never too hot, you're never too cold, you're always just right.
Thank you. You're good? Okay. Oops. What happened with this one? Oh, this was just, okay. Oh, you could- All right, make sure they get the jury ready. Huh? Mr. Alanis, you want to divide up your time? Very good. I'll give you a 5-minute heads up on both ends. 10 minutes, okay. 10 minutes reserved. Okay, okay. Thank you all. Please have a seat. Members of the jury and alternates, I'm about to read you the charge of the court in cause number 2018 CRA 852D1, State of Texas versus Ronald Anthony Burgos-Aviles, a case filed here in Webb County, Texas in the 49th Judicial District. Members of the jury, the defendant, Ronald Anthony Burgos-Aviles, stands charged by indictment with 2 counts of the offense of capital murder, alleged to have been committed in Webb County, Texas on or about the 9th day of April 2018. The defendant has pleaded not guilty. Our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual. Our law provides that a person commits the offense of capital murder
If he commits murder, as hereinbefore defined, and the person intentionally or knowingly causes the death of more than one person during the same criminal transaction. Our law provides that a person commits the offense of capital murder if he commits murder, as hereinbefore defined, and the person intentionally or knowingly causes the death of an individual under 10 years of age. A person acts intentionally or with intent with respect to the nature of his conduct or a result of his conduct when it is his conscience, objective, and desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct or to the circumstances surrounding his conduct when he is aware of the nature of his conduct or that his conduct is reasonably certain to cause the result. Individual means a human being who is alive. You are instructed that you may consider all relevant evidence concerning the relationship that existed between the deceased and the defendant, if any, prior to the alleged killing, the facts and circumstances surrounding the alleged killing, and all of the relevant facts and circumstances showing the condition of the defendant's mind at the time of the alleged killing. Our law provides that the time of the offense alleged in the indictment must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by limitation. The phrase on or about means that the state is not required to prove the alleged offense happened on that exact date. There is no limitation period for the offense of murder and capital murder. Therefore, it is sufficient if the state proves that the offense alleged was committed sometime before June 27th of 2018, which is the date the indictment was filed. Any words not specifically defined are to be given their ordinary meaning, and jurors are free to use any meaning which is acceptable in common speech. Count one. Now, if you find from the evidence beyond reasonable doubt that on or about the 9th day of April of 2018 in Webb County, Texas, the defendant, Ronald Anthony Burgos-Aviles, did intentionally or knowingly cause the deaths of Dominic Alexander Hernandez and Grizelda Hernandez during the same criminal transaction by stabbing Grizelda Hernandez multiple times with a sharp object and by stabbing Dominic Alexander Hernandez in the chest or slashing Dominic Alexander Hernandez's throat with a sharp object, then you will find the defendant, Ronald Anthony Burgos-Aviles, guilty of capital murder as charged in the indictment. Unless you so unanimously find beyond reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant of murder and say by your guilty or by your verdict, not guilty. Count two. Now, if you find from the evidence beyond a reasonable doubt that on or about the 9th day of April of 2018 in Webb County, Texas, the defendant, Ronald Anthony Burgos-Aviles, did intentionally or knowingly cause the death of Dominic Alexander Hernandez, an individual under 10 years of age, by stabbing Dominic Alexander Hernandez in the chest or slashing Dominic Alexander Hernandez's throat with a sharp object, then you will find the defendant, Ronald Anthony Burgos-Aviles, guilty of capital murder as charged in the indictment. Unless you so unanimously find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant of murder and say by your verdict, not guilty. You have heard evidence that the defendant made an oral and recorded statement on April 9th of 2018 during custodial interrogation conducted at the Laredo Police Department by the Laredo Police Detective Rick Reyes and Ernesto Elizondo. If you find the defendant did make the statement, you may consider the statement against the defendant only if you resolve a preliminary question in favor of the state. An oral recorded statement an oral recorded statement by a defendant, should say recorded, by defendant made as a result of custodial interrogation may be considered only if before the statement, but during the recording, one, the defendant was warned that A, he has the right to remain silent and not to make any statement at all, and that any statement he makes may be used against him at the trial. B, any statement he makes may be used as evidence against him in court. C, he has a right to have a lawyer present to advise him before and during any questioning. D, if he is unable to employ a lawyer, he has a right to have a lawyer appointed to advise him before and during any questioning. And E, he has a right to terminate the interview at any time. And two, the defendant knowingly, intelligently, and voluntarily waived the right set out in the warning. Therefore, you may only consider the statement made by the defendant to Detective Reyes and Elizondo on April the 9th, 2018, if you all first agree that the state has proved beyond a reasonable doubt that before the statement was made, but during the recording, and the defendant was given the warning set out above, and knowingly, intelligently, and voluntarily waived his right set out in the warnings. If you do not find that the state has proved these things beyond a reasonable doubt, you must disregard and not consider for any purpose any statement the defendant may have made. If you do not find the state has proved these things beyond a reasonable doubt, you may consider the evidence that the defendant made the statement and give that evidence whatever weight you believe appropriate. I may have said if you do not find. Yeah, if you do find. Paragraph 8. You may consider all of the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and the duty to determine what the facts are in the case. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with an offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant. Unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in this case. In a criminal case, the law permits the defendant to testify in his own behalf, but the same law provides that his failure to testify shall not be considered as a circumstance against him. You will, therefore, not consider the failure of the defendant to testify as a circumstance against him, and you will not, in your retirement, to consider your verdict, allude to, comment on, or in any manner refer to the fact that the defendant has not testified. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution proof excludes all reasonable doubt concerning the defendant's guilt. You are further instructed, as a part of the law in this case, that the indictment against the defendant is not evidence in this case, and that the true and sole use of the indictment is to charge the offense and to inform the defendant of the offense alleged against him. The reading of the indictment to the jury in the statement of the state's case against the defendant cannot be considered as a fact or a circumstance against the defendant in your deliberations. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for a juror to discuss or consider anything which they know or have learned outside of the testimony presented to you and the law contained in this charge. If a juror should discover that they have any outside information They must not mention this information to any other juror nor consider it themselves in arriving at a verdict. You shall not discuss or consider the punishment, if any, which may be assessed against the defendant in the event he is found guilty. You may not discuss this case with any court officer or the attorneys or anyone not on the jury. You must not discuss the case unless you are all present in the jury room. If anyone leaves the jury room, then you must stop your discussions about the case until all of you are present again. You must communicate with the judge only in writing, signed by the foreperson and given to the judge through the officer assigned to you. You must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statements of the attorneys that is inconsistent with the law contained in this charge. The role of the judge is to preside over the trial and to rule on objections and the admissibility of evidence, but not to comment on the weight or credibility such evidence is to be given by the jury. Therefore, the jury shall not draw from the conduct or comments of the judge any inference as to the weight or credibility of evidence admitted before them during trial. You have been permitted to take notes during the testimony in this case. In the event any of you took notes, you may rely on your notes during your deliberations. However, you may not share your notes with the other jurors, and you should not permit the other jurors to share their notes with you. You may not, however, discuss the you may, however, discuss the contents of your notes with the other jurors. You shall not use your notes as authority to persuade the fellow jurors. In your deliberation, give no more and no less weight to the views of a fellow juror just because that juror did or did not take notes. Your notes are not official transcripts. They are personal memory aids, just like the notes of the judge and the notes of the lawyers. Notes are valuable as a stimulant to your memory. On the other hand, you might make an error in observing, or you might make a mistake in recording what you have seen or heard. Therefore, you are not to use your notes as authority to persuade fellow jurors of what the evidence was during the trial. Occasionally, during deliberations, a dispute arises as to the testimony presented. If this should occur in this case, you shall inform the court and request that the court read the portion of the disputed testimony to you from the official transcript. You shall not rely on your notes to resolve the dispute because the notes, if any, are not official transcripts. The dispute must be settled by the official transcript, for it is the official transcript rather than any juror's notes upon which you must base your determination of the facts and ultimately your verdict in this case. You are the exclusive judges of the facts proved, of the credibility of the witness, and of the weights to be given to the testimony. But you are bound to receive the law from the court, which is herein given to you, and be governed thereby. After the reading of this charge, you shall not be permitted to separate from each other, nor shall you talk with anyone not of your jury. After argument of counsel, you will retire and select one of your members as your foreperson. It will be his or her duty to preside at your deliberations and to vote with you in arriving at a unanimous verdict. After you have arrived at your verdict, you may use the form attached hereto by having your foreperson sign his or her name to the particular blank that conforms to your verdict for each count. But in no event shall he or she sign more than one of such blanks on such form. I have the original, which does have the verdict form. Your copies that you have with you are your working copy that you can keep to assist you during deliberations. The original has on top, says original copy, and is signed by me. And it also it also has the corrections on some of the words that I delineated. You'll know exactly which the original is. And this will be the one that the foreperson will have and will sign when the time comes. Mr. Anís?
Your Honor, I'll request an hour and 5 minutes, and I'll reserve 10 minutes.
May it please the court, counsel, ladies and gentlemen of the jury. It's time. It's time. More than 5 years ago, 2 innocent lives were taken. Time has gone by. Court proceedings have been held. We've lived through COVID. Court dockets move slowly. But throughout all of this time, 2 beloved individuals have been missed by their families, by their community. Grizelda and Dominic. And this is why we're here today. This is who we are here for. Think back to the day on May the 2nd, when close to 400 people, 400 Laredoans like yourself, came together at TAMI. You answered the call, showed up, not knowing what type of case you were going to hear. Little did you know that you would be part of one of the biggest cases in the history of Laredo. When you came to court and were selected for this very big and important case, you rose your hand and you made a promise. You each remember sitting in this witness chair as we questioned you to find 12 fair and impartial members of our community to hear this very big and important case. And you answered the call. And you are now in the box. It's time. You remember when we were at TAMI, Texas would give you a professional presentation of this case. And we have worked hard and diligently to bring you all of the evidence. Because we spoke about that. That's how important this case is. It's important to Mr. Burgos, but it's important to the state, it's important to the victims, it's important to the community. Because what are we seeking? What are we after? Through all the evidence, through all the facts. Truth. Truth. And we have spent the last 7 days bringing you evidence, seeking the truth. And I submit that we have proven the truth beyond a reasonable doubt. Why do we go through all this trouble in the United States of America? For justice. For justice. Justice for the victims. Justice for the accused. We have all the faith in each and every one of you to make the right decision, and the only decision in this case. And what is that decision? What is that verdict? Each and every one of you know, when you use your common sense, when you review all the evidence, when you weigh all the credibility of the witnesses and of the evidence, you know the answer. You know the answer. It doesn't matter what I believe, it is what the jury is going to believe. You remember that statement during the interview? You remember Detective Reyes telling that to this man that is sitting here today? He couldn't be more right. It's what you believe. It's what the evidence shows. Now, I told you in opening statement, I said, we're going to take you to Father Magdalene Park. We're going to take you to that dirt trail. Now, we didn't put you in a bus and take you, but how did we take you there? We took you there with evidence, with videos, testimony, photos, physical evidence, forensic evidence. We have accounted for almost every minute of his movement on April the 9th of 2018. Think about that. Think about that. And we've narrowed it down. And you heard me ask the question to lead detective Raimundo Garcia. When that last Snapchat was sent, well, she was still alive. She was still alive. Remember the time? Remember what time it was? 9:44. 9:44. She made that 10 to 12 to 13, 14-minute walk, pushing her stroller, pushing her baby with his Doritos, holding his phone into the trap. 9:44. 10:10. He's on the camera. The other time that we can't account for are those 5 minutes behind the church. Remember that. What happened behind there? Why would he go on April the 7th to scout it out and then go back there after he got in his Kilo unit when he left the house at 10:37? What was he doing back there? Use your common sense. I told you in opening that Ronald Anthony Burgos-Aviles is a danger. He is a danger to the family, to Grizelda's family, to law enforcement.
Objection, Your Honor.
It's argument, Your Honor.
That it's the appropriate time for this option.
What did Detective Garcia say when he heard the transmission from Gilbert Benavides? St. Anthony Burgos. Grizelda went to go visit her ex or her baby's father, Anthony Burgos. What did the detective testify? He had a surge of adrenaline. He felt fear. He felt fear for his fellow officers. The killer was among them. He was armed. He was dangerous. And he's a danger within society. Why? Because he hides behind the badge. Credibility. Instant credibility. I told you in opening that every story has a beginning, a middle, and an end. This story didn't start on April the 9th of 2018. I told you in opening that we were going to go back to the beginning of how this started, and it started in 2015. That's when they meet online. They enter a secret relationship. She gets pregnant. And little baby Dominic is born when? On July the 26th, 2016. In the beginning, it's Grizelda Hernandez, Dominic. And who's missing from that relationship? Ronald Anthony Bugos-Aviles. What did the evidence show? The evidence showed that for the first 18 months of this baby's life, Grizelda raised, supported, used her student loans for daycare. Not a single penny, not a single dollar given by the presumed father. What did she want? What did she want? She wanted what every mother would want. She had dreams. You saw in her text messages to Anthony and also to her family, she was studying to be a nurse, like her big sister Angelica. She had ambitions. You saw, you read her words where she didn't want to cause this guy any trouble. She even said, maybe even before the baby turns 18, I won't need you anymore. But right now it's hard as hell. Help me out. I'm not trying to be mean or anything. The text messages are there, ladies and gentlemen. You'll be able to read them. All the evidence that we brought, all the evidence that we put on this projector, you're going to have it. You can review it. She had hope. She had hope. And you know, hope is a very powerful emotion. Hope is something that keeps dreams alive. It helps keep dreams alive. Hope is something that gives people inspiration. What did she want? She wanted her baby to be loved. She wanted her baby to be accepted, to be acknowledged. It wasn't anything monumental, but it was something very important. She wasn't out to wreck his life. What would have been wrong giving this little beautiful baby a chance? What would have been wrong with that? He never gave him a chance. The most innocent of our society, the most vulnerable of our society are our children. Our children. They don't get to select who their parents are. And parents have a responsibility to love their children. It's not that hard. It's not that hard. But what happens in this case? You saw the practice text when she texted herself saying, hey, I don't know how to tell you this, but I really need help in December. And then in January, we took you into the inner discussions between Grizelda and Ronald Anthony Burgos-Aviles to show you how he was manipulating her. He would play the guilt game. I started to have a heart 2 days ago, but not anymore. Then he would go into the sex talk, but he would never reveal his rage. Very careful not to scare her away. Very selective on how to bring her near so that he could have that opportunity. Time was running out. Time was running out. His reality check is when he gets the child support paperwork. What does that mean? What did it mean in his life? Threats. He perceived that action as threats. Threats to his marriage, threats to his job, to his career, his lifestyle, his bank account. Who was the biggest threat? This little baby was the biggest threat. Remember, I told you, pay attention to the details. Pay attention to the details. You know what? We're lawyers. We go through this over and over and over again, preparing ourselves, but we're only human. Study the evidence, the details. One of the details I noticed was that he never calls Dominic by his name. The baby, el nene. Why? How's Dominic? What's wrong with saying, how's Dominic? Give him his name. Call him by his name. Not even that. The threat is this innocent little baby. And who does he have to get through? Remember? The mama bear. And what does every mother do? Every mother will protect. Every mother will fight. Every mother will die to protect their child. The first meeting in Winfield. It's there. It's there in black and white. Evidence of the first meeting that he set up. We brought you the analysis by FBI cast agent, putting them there. We put them both at the park on March the 25th. And what I put up there is the insect bite in quotations. There's been a lot of testimony on the insect bite. Again, use your common sense, okay? Use your common sense. Go back in time with the evidence that we brought you And it is perfectly logical. It is perfectly logical that everyone in the medical community, even her own sister, a registered nurse, thought it was an insect bite. There is no way that anybody could even fathom that somebody would inject a baby. Do hospitals, do emergency rooms, do pediatricians, do clinics make mistakes in diagnosis? Yes, they do. Yes, they do. And what is the number one factor that every physician, every ER room, every clinic relies on when any patient goes in? The history provided by the patient or caretaker. Those were the working conditions or diagnoses that the doctors were working with. They worked with what they got. And yes, there was one expert after the fact, after the plane crash, go in and do the forensics, that's able to say, hey, wait a minute, this wasn't an insect bite. One person who had the expertise and the courage to come here and call it what it was. And we had to, and she was brought back twice and raked through the coals. You be the judges of Dr. Stern's testimony. Use your common sense. Who mentions it first about necrosis? He does. You know he could get necrosis, right? He does. What happens on April the 4th of 2018? Stops communications on Facebook Messenger. Here they are. These are the Facebook records that law enforcement got. Same time period. Grizelda's on top. Ronald Anthony Burgos-Aviles on the bottom, side by side. Grizelda's and his. What happened to the communications that he had leading up to the murder? They're gone. You'll have this, but they are in hers. It's in the details. Look at that little ghost on the Snapchat. Remember, I asked Detective Garcia, well, what's the deal with Snapchat? What's the advantage? Well, they delete, and I said, you mean they disappear? He goes, yes, they disappear. The messages show up, and they disappear into space. That man, Ronald Anthony Bugos-Aviles, switched his comms, his communications to Snapchat leading up to the murder. Follow the evidence. intentionally, knowingly, planning. The final meeting, you have the text message from Grizelda to her sister asking her for the white card. Remember the white card? That famous white car, the Mercedes that he, and we'll get into it, but when he goes into the interviews, April 9th, 2018. The timeline. Through the concerted effort of law enforcement, the DA's office, Laredo Police Department, FBI, Customs and Border Protection, everyone, all hands on deck. Double homicide, all the resources to find the killer. We brought it to you. You saw the level of investigation that was done. From the moment he left his house, we have the video. When he arrives at the Border Patrol station, in his uniform, you remember, and I'll get into that right now. The morning of April 9th at 8:29, remember his vehicle is spotted or marked at the crime scene. It's at the crime scene early that morning. Grizelda and Dominic arrive around 9:05. He Snapchats at 9:27. The Snapchat records are in evidence. We went over them with you. You see that the sender and the person who received it. Grizelda's final Snapchat at 9:44. She was still alive. Probably walking and getting near the dirt trail. The radio GPS places Burgos-Aviles at 9:49. Remember, what did Miss Stevens say when you turn off the unit? The GPS marks. Remember that at 9:49? And what was the next time? 10:10. Twice he turns it off. She's walking into the trap around 9:45, 9:46. The last transmission we have and photograph that you saw off of the camera, the drawbridge camera from DPS is at 10:10. 16 minutes. In there is when he took 2 lives. He departs the crime scene at 10:10. He arrives home in shorts. You saw it. He was in uniform that morning. He's arriving at home with shorts and tennies. 10:37, 10 minutes later, he's getting back in his kilo unit, 66119. As he's stepping on, watch the video, you'll see he's in socks. You'll see he's not wearing his boots. Where are his boots? His boots are in the kilo unit. He puts them on. Phones travel with him, with Burgos-Aviles. The phones. Teléfonos. He forgot the phones. He speaks to Agent Dennison, Agent Lara. 11:18. That's when he discovers the body of the female.
Copy 6-8. Hey, bro, I need your help right here, bro. By Bristol, man. Hey, 946-8, I'm gonna need EMS ASAP at the end of Bristol. River, Bristol, the River Road, the ATV trail. And this is subject here needs help ASAP. 940, I don't know yet. Stand by. Let me go check. Just have them come over here. Yeah, 10-4. I'm here with Lara. Any other agents heading this way? Just stand by. Stand by.
The crime scene. The crime scene. 11:18. He goes back to that brushy area along the river where he lied in wait. He used his skills. He used the brush. He used the camouflage to ambush. And with vicious and violent blows, attacks Grizelda. The evidence is there. It's in the autopsy reports. But panic equals mistakes. Panic equals mistakes. You remember, you saw the photos, the phones. These were found in Kilo Unit 66119. Grizelda's and Dominic's phones. Can you imagine? Can you imagine the amount of adrenaline and fear running through his veins after he just killed two innocent people in cold blood? One being his own son and the mother of that innocent baby. And then trying to stage the crime. Can you imagine the adrenaline rush running through the veins of trying to get out of there and make it look like someone else attacked these two people? And that's why he made mistakes. That's how those phones ended up right here, right on his vest. And that's why his belt keeper that holds his Sam Brown, where's the these belt keepers, you heard officer after officer testify. How many of these are standard in order to hold this up to your belt? 4. This one, full of dirt, full of mud, found under the driver's seat with Grizelda's blood. She marked her killer. She marked her killer. You have the photos. The dirt trail tells a story. Remember, I told you that in opening. That dirt trail that we took you there through all of the evidence, all of the photographs, the video, tells a story. It tells a tragic and horrific story of the last seconds of two people's lives who lives should not have ended that way. It is hard to comprehend why people murder. That's not, motive is not an element. No matter what reasons he had, he did not have the right to end their lives. Not like that. Not the way he did. Not a law enforcement officer. Not a young mother. Not an innocent baby. She went there that day with hope that he would accept his son. This is how he left her. This is how he left her. You know what? Maybe it was some dogs. Maybe she got beat up last night. He had the audacity to say that. And this is how he left this innocent baby. Drenched in blood. It's in evidence. 5 or 6 bags of hair found on the trail. Hair, long strands of hair that were cut off. You saw the number of clusters of stab wounds to the back of her head. Long hair on the dirt trail. The bloody rock drenched with her blood. What does he do? He walks over the trail, kicks the rock, moves the rock, drags his feet. You remember all that testimony. The shoes. The left shoe, he comes walking and throws it by her body. The right shoe found over there by the river, trying to make it seem like she was coming from the riverbanks, staging the crime. What did I tell you? What did I tell you at jury selection? The biggest enemy that law enforcement has in trying to solve a crime is time. Who decides where? Who decides when? Who decides how to commit the crime? Who's able to plan it? He's able to plan it. He's able to decide when, where, how. That's what the evidence shows. Every little detail. You have it. Maybe Dominic speaks to you guys with his innocent blood. With his fresh haircut that the officer Cortez testified to. You just need to listen. All you need to do is listen. And if you listen, you'll learn. Look at the evidence. Look at it. Listen to it. Learn from it. It's there. Look at the shirt. Do you see where the knife went through the shirt? Do you see where the knife went through the shirt? Do you see where that knife went into that 1-inch penetrating cut to the chest? No. You don't see it because it's not there. The person who punctured that little sternum didn't go through the shirt. He lifted it. And he went for the heart. That man who sits here today, the United States Border Patrol supervisory agent, he went for the heart of this innocent, beautiful baby boy. Dominic's clues. Listen. He speaks to us. How does he speak to us? Little Dominic put his blood everywhere so law enforcement can find it. So that Miss Nicole, who came here, and she said, well, let me tell you something, Mr. Boggs. It may be meaningless to you, but it's not meaningless to me. Remember that? It's not meaningless to me. I do the analysis. I make the match with what I got. There was no contamination in this case. There was no contamination. The evidence was preserved. The chain of custody was followed. It was taken to the lab at Bexar County. You got that expert who came over here with no agenda, no motive, no conspiracy, but only to tell the truth. And what did it show? You have the DNA results. Dominic's blood on his mother's phone and mama's blood on Dominic's phone. Mama's blood on Dominic's phone. What does that tell you? What does that tell you? He kills Grizelda. His hands are full of blood. He goes to Dominic's stroller. He unbuckles him with his hands full of Grizelda's blood. It's on Exhibit 4. Nicole told you, Grizelda's blood on the stroller, where I told you he unbuckled the baby. There's blood splatters on the canopy where she was attacked from behind, and the blood falls on the canopy. The fight goes 20 to 25 yards down the dirt trail till she finally loses the fight. She's overpowered by strength and violence. He goes, gets the baby. He's probably playing with his phone. He puts her blood on his phone, on that cricket. He takes him over. He kills him. Then what? I need to go get her phone. Then he goes back. He grabs Grizelda's phone. And guess what? He puts Dominic's blood on her phone. He throws him in the truck. Then he's full of blood. He goes by the tailgate. There it is. He rubs the tailgate. Maybe when he's taking off the pants. Maybe when he's leaning, trying to take off the tennies. The blood transfer. Dominic says, tag, you're it. Mark's the killer. You need to listen. Look at that. And then the blood inside the truck, the blood flakes. Blood everywhere. He didn't count for that. He did not plan for that. He did not plan for that fight. Grizelda speaks to you also with her blood on the rock, her blood on the stroller, on the canopy, on the belt keeper, and on her little angel's phone, her blood. It's all there for you. His statement, voluntarily, knowingly, and in his training. You have it. You have it here. The Miranda warnings. You saw the recording. What did it say? Let's just get to it, man. Come over here. I want to talk to you. Let's just get to it. This is a law enforcement officer, okay? This is not your ordinary Joe Blow. This guy, he's a supervisor. He's taking courses. He's certified. He's taken courses on crime scene preservation. Here you go. You have it right here. He's got the transfer of physical evidence. It's in here. These are the courses. This guy, he moved up through the ranks there at Border Patrol. Miranda training, States Exhibit 515.9, right here. You can't say that he didn't know what his rights were. Because he's somebody that has sat on the other side of the table reading Miranda warnings to people who he may arrest. He's knowledgeable. You saw his demeanor in that room. You saw the charades he was playing, the act that he was putting on. Well, I don't know about that shit about crime scenes. Really? Basic, but Lara does? Dennison does? No, I don't know anything about that. Deflecting. Always deflecting. Now, you have the benefit now of sitting here for 7 days and getting all the evidence. What he didn't know back then, as he sat there on April the 9th, was that all of his lies were going to be exposed through a thorough investigation. Okay, so now we have the benefit of the investigation to compare to his statement back then at the time, and you get to see how he's attempting to manipulate the situation. These are just some examples. Oh, there's a dead body, you know, there's dead people. Listen to his statements throughout the initial stages. He uses people. Was it a person? It was a girl. Starts getting confused. We are the Border Patrol. We don't got shit about crime scene shit. That's what he says. That's not true. I mean, she could have been unconscious. I can't, what do you say? I don't want to call in and say she's dead. I mean, every officer, every law enforcement officer that was there said she was deceased, right? So what does he do? He wants to deflect. He says, I don't, maybe she was unconscious. Then he says, well, Lara said, I don't think she's gone yet. You heard Agent Lara. We're going to go over his testimony. Agent Lara never said that. At the time, I only thought she got beat up. This is the woman who has his baby, okay? This is the woman who has his 18-month-old son, who he denies. He denies her. Lara said something about dogs. I found the shoe. I found the stroller. He didn't find the shoe. the shoe that he brought over, then he tries to take credit for finding a stroller. You heard Agent Dennison. You heard Agent Dennison. I don't know whose car it is. How many times through the evidence did you see the white Mercedes being discussed prior to this date? And he has the audacity to sit there and tell two homicide detectives that he doesn't know and he's never seen that car before. And then, well, maybe I've seen that car, right? Lying that was the first time he saw that car. Well, it rings a bell. That was the most they got out of him. It rings a bell. Well, I saw her 2-3 weeks ago. It's like you killed her this morning. If you snapped, what did Reyes tell him? Listen, man, you know, just tell us the truth, man. Oh, the last time I saw her was 2 or 3 weeks ago. Last time I talked to her was about maybe a week ago. Come on, dude, you. And he's real smart. He goes, check the phone. Check the phone. Thinking about Snapchat, right? Those messages disappear. So he's challenging the law enforcement, right? She was smarter than him. She took some screenshots of some of the Snapchats, remember? She went into that tile, takes a screenshot. Something in her told her not to trust him. And she took those screenshots. I wasn't supposed to meet no one. Continue. He denies meeting the child. Hard to explain the situation for the fucking jury. If you're looking for me to say I shot her in the face, I can't do that shit, man. Do you know why? Because I'm not going to fucking jail for something I didn't fucking do. He likes to throw out the F-bombs as a default. I don't know if you noticed that every time he's confronted with the truth, he starts throwing F-bombs to deflect. Because of this shit, because I hit it 2 years ago, I'm fucking guilty of it. Because I hit it 2 years ago, because he got her pregnant. Listen to the way he's talking about the person that he just killed. No remorse. It ain't fucking fair. You saw it. You listened to it. He says that. It ain't fucking fair. No. It was never like that, man. She was never on you like that. I'm telling you, she's not that type of person. She was never like that. Oh, you better man up and this and that. It looks like she took a beating from last night or whatever. It's a fucking major coincidence. You know what? He's right. He is right about one thing. She wasn't out to destroy him. She wasn't out to ruin his life. She just wanted support for his baby. Man up. Help me out. This little boy that looks like you, he almost identical to his own son. Never a moment of clarity. Never a moment of saying, wait a minute, what am I doing? There was still time. There was still time after he killed Grizelda. There was still time to stop. Leave the baby in the grass. Stop. That tells you how depraved of a heart he has to follow through. And when Dominic didn't die with the first stab, what does he do? He transects the jugular, the carotid. It's not a mystery. I know what's coming because I'm not fucking stupid. I know what's fucking coming. I can freaking easily show you guys that me and her were fucking good. I never had an issue with her. That's right. That's right. Never had an issue with her. So why kill her? I won't give you fucking shit. Remember when he asked, well, let us see your phone. Let us help you. You know, we want to help prove, you know, clear you from this. Can we see your phone? Now, I'm not going to give you fucking shit. No way. I'm not giving you the password of my phone. I didn't speak with her today. Probably, I'm gonna apologize for. You're gonna apologize for investigating me. I'm gonna want an apology when all this is done. And then Reyes walks in and he's like, "Well, I was just telling him about the child support." Did you remember Elizondo? Hey, dude, you didn't mention that, dude. What are you saying? Well, yeah, you know, I tried to tell you about the process, man. Dude, you didn't tell me anything about the child support. Lie after lie after lie after lie after lie. We brought you state's witnesses. Angelica Hernandez. You heard her, the sister. She confirmed the relationship with Anthony. Even the name that he gave her at the beginning was his middle name. So that later on, if things got ugly, he was Anthony. He wasn't Ronald. He was Anthony. He challenged Reyes at the time, hey, take me to go see the sister. Why? Because they had never seen him. Aren't you going to take me? Take me to who's accusing me? Hey, dude, take me over there so that they could see me. Because he knew that they had never seen him. She confirmed the April 9th meeting. She owns a Mercedes-Benz. You heard from her how she lent it to her sister. And she also was the one that went to call Dr. Stern on April the 12th to say, Dr. Stern, please check my nephew. I don't think it was an insect bite. That's how it all started. Dr. Rodriguez, he had a working diagnosis. But one of the most important things that came out of Dr. Rodriguez's testimony was when I asked him, okay, now that the word syringe has come out, would that change your diagnosis? He said, that would expand, was the word he used. I wrote it down. That would expand my working diagnosis. Meaning, so it would open it up to another diagnosis? Yes. But I don't remember what he called it. You all heard him. I mean, it was a puncture, right? A pinpoint type lesion, I think he said. Pinpoint lesion. So you mean a puncture? Yeah, it was a puncture. But now we're introducing syringes into the formula. He's like, okay, well, I didn't know that then, but now if you're telling me they found syringes, maybe my working diagnosis would expand. I was going with what the ER had said and what the clinic had said. What was also significant about him was he said Dominic's condition never improved. His condition was actually getting worse. I wish that we would be able to find out what substance was put in him. And I wish that we could have found the weapon, and I wish we could have found the bloody clothes. But we have given you enough beyond a reasonable doubt to convict. Dr. Corinne Stern. Dr. Corinne Stern. You didn't hear from her once, you heard from her twice. She didn't perform the autopsy. But based on something that's rarely happened to her in her career, you heard her, right? She had a family member come over there and say, please check my nephew's leg. Now that he's dead, it all makes sense. Please check his leg. She goes, she cuts open the leg, she finds the black, dead, necrotic tissue deep in the tissue. And she calls it like she sees it, plain and simple. They want to say, well, you in Alabama, you had all these other medical pathologists that turned on you and testified against you, and that the DA dismissed your case. Hey, we're not in Alabama. We're in Texas. And we do things differently in Texas. We need to send Alabama a message, because she's telling you the truth. Common sense. Common sense. Even today when I ask her, do you still stand by your opinion? I absolutely do. She never tried to make herself out as being some super medical pathologist, that Nobel Prize winner. She just, hey, I'm a medical examiner, and this is what I saw. You guys can believe it or not. That's what I saw. And that's my opinion. You guys are the ones that decide. Adriana Flores, she's a criminal her friend. What was it with her? She said, I was the last one. How do I look? Wish me luck. How do I look? Wish me luck. The last one to see her alive. Bradley Dennison. This guy's I tell you what, an amazing agent on what he did that day. One of the most significant parts of his testimony was when he said, to me, it looked like an ambush. This guy's 17 years walking the brush in South Texas, cutting trails, looking for sign. And what did he tell you? There was a circle or a patch of grass where somebody was pressing the grass. Okay, let's go with that. Imagine you're about to kill your own son and the mother, and you're hiding in the grass, and you're getting ready to do this violent act. And you're waiting, and you're pacing, and you're getting yourself ready to do this. Now, I doubt he was just sitting there calm, leaning on a tree. This guy was getting pumped up for the moment of truth. It was going to happen. And the grass was there. It was pressed down on the side of the trail. Lara, you heard him. The odd behavior that he saw. He takes the lead, and he sees all the contamination that his supervisor is doing. It doesn't make sense, but it makes sense later on. Elizabeth Stevens, Motorola, she places him, and you saw my co-counsel when he questioning her. She puts him right at the Border Patrol Station North, puts him on that trail through Motorola. Albert Cortez, he's the first officer on the scene. It's a bloody crime scene. He says Dominic looked like he was placed, not thrown. Gilbert Benavides, you remember his testimony?
This is going to be the 20th. She's at this morning, and she hasn't answered for the last 4 hours. She was supposed to be baby daddy or the ex, Anthony Burgos, who's a Border Patrol agent.
What did he tell Detective Ricardo Ramirez? I don't even know who the owner of the car is. I have lots of exes. But if you could extend me 5 minutes, please. I have lots of exes, he tells the detective. I don't even know who's in that car. He takes the belt. He takes the belt off of him, and it just falls in his hands. He catches it. He also takes the phone, puts him in the unit, and you remember what he says when he gets in the unit, right? Teléfonos. Andrew Masters, FBI certified. What was one of the main emphasis by FBI agent Masters. He used 5 independent sources to make his analysis. It wasn't one. There was a big, there was a big emphasis put on, well, Sprint gives you this disclaimer. He was trying to explain, I just was not using Sprint by itself. I'm using a combination of different sources. Now, if a source on the antenna says that they're outside the Webb County Courthouse, okay, and then a camera from City Hall picks up the car there, well, then you can conclude that the signal was accurate. He put layer after layer after layer after layer after layer. And that's how we were able to put together for you that compilation. All the sources yielded the same results. And it places Burgos-Aviles and Grizelda's phones at the crime scene, at his house, and all the important places. Adriana Escamilla, she's the investigator. She gets the camera from the drawbridge image. She gets the work schedule, the vehicle assignment, his certifications, and the child support letter at his desk. One of the most interesting courses that he took was on the weapons course. He was certified. Dealing with knives, you have it there. This guy was trained, he was skilled, okay? There was only 2 units with that spotlight on duty that day. Kilo 66119 being driven by this man right here, Ronald Anthony Bugos-Aviles, on the job, wearing his uniform under the color of law, commits a double homicide. Nicole Morales, she establishes Burgos-Aviles as a father. You have her DNA analysis. There it is. The stroller, Grizelda. The canopy, Grizelda. The headrest, Grizelda. The belt buckle, Grizelda. The belt keeper, Grizelda. The rock, Grizelda. The passenger door, Grizelda. The cricket phone, Grizelda. The rear passenger floorboard of the Kilo unit, Dominic. The cricket phone, Dominic. The ZTE phone, Dominic. The tailgate, Dominic. The science doesn't lie. The science doesn't lie. Detective Rick Reyes, Ronald. Remember, he gives him that incomplete name, trying to throw him off. Why? Because they know him as Anthony. It's like, dude, tell me your fucking name. Well, that's because you didn't ask me. Web of lies. 27 stab wounds, Dr. Hernandez. The carotid and jugular are transected. Ladies and gentlemen, the person who did this, the individual that did this, had, what did he say? They had knowledge. They had knowledge on where and how to kill the person. You have the evidence. The 27 stab wounds to her head, her shoulders, her arms, her wrists, her hands, her back, her ear. All at the hands of this man. Supervisory Border Patrol Agent Ronald Anthony Burgos-Aviles. What does he say? Targeted the vital areas with a sharp object. And what was most amazing of his testimony is that both mother and child were killed in the same fashion, transecting the jugular and the carotid arteries on the same side. You have it. He knew what he was doing in ending their lives. The detective, lead investigator, he brought you the digital evidence, the video surveillance, Facebook, Snapchat, the timeline, the syringes. It's not a coincidence. Dr. Stern said, find some syringes in the lunchbox. Weeks later, syringes are found. They bring you evidence of him being on testosterone. That's fine. All it does is establish that he has access to syringes. What did he put in that child on March the 25th? Intent. Knowingly. Trying to end him.
Hey, he's the guy that found the body. He's the border patrol agent that found the body. Does anybody have visual on him?
What's missing? The murder weapon, the bloody clothes, and the 5 minutes by the church. Everything under his control. The murder weapon, the bloody clothes, and the 5 minutes by the church. There he is, calculating, manipulative, and deceptive, hiding behind the badge. Lucky they are. Think about that. What were the last words that Adriana said to Grizelda, or what Grizelda said to Adriana? Wish me luck. How do I look? Wish me luck. And then the little baby is wearing a shirt of Baby Yoda, and it says, "Lucky I am." And I'll tell you what, the luck wasn't with him on that day. It wasn't with him on that day. But the luck is with him now. The luck is with him now because they have you. They have you. He's guilty. The only thing left for you to do is to go in there and find him guilty on both counts. Find him guilty.
Members of your I really believe that our criminal justice system is also upon which it is based only then will it function properly. Never imagine the only thing left to go into the jury room. Finding guilty without deliberate blown, some flags of dirt with blood on them. Mr. Burgos is the mobile radio. But the state's expert testified under cross-examination that she only measured degrees of latitude and the longitude. She did not include hour or minute measurements, which are intended to produce a more precise location. It's kind of like reading a clock. If I just read the hour, and then one tell you it's 9 o'clock.
physical evidence. Everything that we brought you over these last 7 days. That you'll be able to go home tonight and have a clear conscience. That you did your job. That you weighed all the evidence. And most important, that you brought justice. That you brought justice to baby Dominic and to Grizelda. Thank you.
Thank you, Danny. Ladies and gentlemen of the jury, I'm now about to send you into the jury room, which will become your jury deliberation room. Will you follow the instructions I've given you in the charge and start deliberating? Mr. Rubio will have the 4 alternates step out to another room. You will not be in the same deliberation room. You will be in another room, waiting to see if, in fact, your services will be needed. Thank you.
Okay, that had to be the worst ever. Let me see if I can find where the defense started. Or should I go for the entire closing arguments again? Let me see about how long that is. It's like it's about an hour and 40 minutes. Okay, let me scan a little more here. Okay, I think this is about.
There was only 2 units with that spotlight on duty that day. The rear passenger floorboard of the Kilo unit, Dominic. The cricket phone, Dominic. Behind the badge. But the luck is with them now. The luck is with them now. Because they have you. Grizelda, or what Grizelda said to Adriana, wish me luck. How do I look? Wish me luck. And then the little baby is wearing a shirt, a baby Yoda, and it says, lucky man. And I'll tell you what, it wasn't with them on that day.
Only if we're.
They are. Think about that. What were the last words that Adriana said to Grizelda? Or what Grizelda said to Adriana? Wish me luck. How do I look? Wish me luck. And then the little baby is wearing a shirt, a baby Yoda, and it says, lucky I am. And I'll tell you what, the luck wasn't with them on that day. It wasn't with them on that day. But the luck is with them now. The luck is with them now because they have you. They have you. He's guilty. The only thing left for you to do is go in there. Find him. Guilty. On both counts. Find him guilty.
You may proceed.
Your Honor, counsel, members of the jury. I really believe that our criminal justice system is the best in the world, but only if we apply the legal principles upon which it is based. Only then will it function properly. I never imagined that I would hear Mr. Hernandez tell you the only thing left to do is to go into the jury room and find him guilty without deliberating, without looking at the evidence. That's not how our system works, ladies and gentlemen. I understand, I get it. We have a dead mother, we have a dead child, and it's a type of case that elicits very strong emotions. But that's exactly why we have to adhere to the legal principles that are the foundation of our criminal justice system, because that system is designed to minimize, not to completely remove the possibility of an innocent person being convicted, but to minimize the odds of that happening. And so when you make an argument that is based on anger, on emotion, on displaying bloody clothes that proof that somebody was murdered, but they don't tell you a thing about who committed the murder. What is the approach? The approach is to elicit the mentality of a lynch mob. That's the last thing that we need in a case in which the state is seeking death against the defendant. The most important principle that you can take with you into the jury room is to deliberate with reason, with fairness, with extreme caution, and leave the emotion for when you're done with your duty. If I can have slide number 2. First, we begin with a legal proposition that all persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. And that's the very basic principle of our legal system. The defendant is not required to prove his innocence. The state has to prove it. They have to do it with rational, persuasive evidence, not by wrenching emotions that want you, the jury, to just get vengeance or revenge on somebody. That's not how it's supposed to work. Slide number is so vital to our criminal justice system that it's embodied in state law and in federal law. In state law, you find it in Article 3803 of the Code of Criminal Procedure. And then it's also embodied in the Due Process Clause of the 14th Amendment to the United States Constitution, which guarantees all persons a right to the presumption of innocence. The presumption of innocence is not specifically set forth in the Constitution, but the U.S. Supreme Court has long held that it is a very essential component of our criminal justice. That assumption that Mr. Burgos is innocent. You remember during jury selection, a verdict based on the law and the evidence. Well, now they seem to have forgotten that. Now they want a verdict based on bias and prejudice. And that's what you have to set aside and take a look at the evidence. This is largely, almost entirely, a circumstantial evidence case. And although circumstantial evidence may carry as much weight as direct evidence, the pieces have to fit together for you to be able to actually arrive at a verdict of guilt. Slide number 4. The burden of proof is always on the state, and the defendant is never required to present any witnesses or evidence. If the state fails to prove its case beyond a reasonable doubt, it's the duty of the jury to find the defendant not guilty and to acquit him. And reasonable doubt, I would remind you, is the highest level of proof that we have under our criminal justice system. The state has told you during voir dire that the state does not have to prove its case beyond all doubt, and that is true, but I'd like to give you some legal standards of proof that also are not what is meant by beyond a reasonable doubt. Slide number 6 shows you that a reasonable suspicion is not proof beyond a reasonable doubt. A reasonable suspicion is a fairly low level of proof. It's the level of proof that an officer needs to have to conduct a brief investigatory stop. And then we also have probable cause. And probable cause is another level of proof, higher than a reasonable suspicion, but it still does not rise to the level of proof beyond a reasonable doubt. A probable cause is the level of proof required to issue a search warrant or an arrest warrant. So it's a higher standard of proof than reasonable suspicion, but still well below the level of proof beyond a reasonable doubt. And then we have a preponderance of the evidence, which is the standard used in civil cases. And in civil cases, people are usually fighting over property or money, and so it doesn't require as much proof as our system requires to deprive a person of his life or his liberty, which is what we have in this case. Proof beyond a reasonable doubt is the high standard of proof in the American legal system because the law does not contemplate that it should be easy for the government or the state to deprive a person of his life or his liberty. So that is the standard by which you must decide the fate of Mr. Burgos-Aviles. Has the state put its case beyond a reasonable doubt? A person who is accused of a crime has an absolute right, slide number 7, It's an absolute right to either testify or remain silent. And if he decides not to testify, no inference of guilt may be made from that decision. It's an absolute right to either testify or not testify. There may be many reasons why a person may choose not to testify. You may feel that the state simply didn't present sufficient evidence to prove the case against you. He may have a speech impediment. He may just not be a good speaker. And so the law, in its wisdom, has decreed that a person has that absolute right to remain silent. And it's something that you have to respect. Don't question why Mr. Burgos made that decision. It's his decision alone, and it should be completely disregarded in deliberating on his guilt or his innocence. Now, slide number 8. The state's case is based primarily on circumstantial evidence. So it's important that you understand the difference between direct evidence and circumstantial evidence. Direct evidence is evidence that directly points to the defendant as the one who committed the crime. For example, eyewitness testimony, somebody comes in here and says, I saw X shoot Y. And I'm sure it was X. I've known him for a long time. I can positively identify him. And I saw him shoot the victim. That's direct evidence. A confession by the defendant is also direct evidence. Circumstantial evidence, on the other hand, is evidence from which the jury can reasonably reach an inference that points to the guilt of the defendant. And although the jury can make reasonable inferences from the evidence, they are not allowed to speculate. A reasonable inference is a conclusion based on known facts, where speculation requires guessing what the facts are. Slide number 11. For example, Detective Richard Reyes testifies that Mr. Burgos became a suspect because he failed to give investigators his full name and only identified himself as Ronald Bugos. But everybody at Border Patrol knew him as Ronald Bugos. His name tag only said R. Bugos. And then Detective Raimundo Garcia, who was the last one to testify, admitted that when he first arrived at the scene of the crime, he Border Patrol agents there. It was Bradley Demison, Mr. Burgos, and Francisco Lara. And the first one that he spoke to was the agent who reported finding the body, which was Mr. Burgos. And he asked him to identify himself. And Mr. Burgos handed him his ID, which showed his complete name. Ronald Anthony Burgos-Aviles. And so the cops very quickly jumped to the conclusion he didn't tell us to run to the car, take your belt off, and away they take him. And so this is the type of circumstantial evidence that you can't base a reasonable inference on, because the evidence itself may not be true. So before you reach a reasonable inference from a piece of circumstantial evidence, you have to find beyond a reasonable doubt that the circumstantial evidence itself is true. If it's not true, you can't reach any reasonable inference from evidence that it's not true. And that's a prime example right there. Slide 13. The state also claims that Ronald was intentionally contaminating the crime scene. The Border Patrol agent Lada, while accusing Mr. Burgos of contaminating the crime scene, was himself contaminating the crime scene. Remember, he got a pair of gloves from an agent that he was trading. Smith is what I recall his last name was. He only got one pair of gloves, so he put one on and gave the other one to Mr. Burgos. And he touched Grizelda's body, checking for the pulse, the same thing as Mr. Burgos did. And then he threw the bloody glove on the tree limb, and then realized, I'm contaminating the crime scene. So what does he do? He picks it up, and instead of placing it in a plastic bag or a receptacle where he can deliver it to the cops without further contaminating it, he throws it in Mr. Burgos' pickup truck, in the bed of the truck. Now, there was also blood on the side of the truck. I imagine it occurred the same way. Either Lara or somebody else. There were a lot of cops walking in the area. It was chaotic. There were Border Patrol agents there. There were EMTs. There was a helicopter hovering overhead, probably spreading flecks of dirt all over the place. If anybody opened the door to Mr. Burgos' vehicle when the helicopter was overhead, it could have easily blown some flecks of dirt with blood on them into Mr. Burgos' vehicle. Slide number 14. The state also relies on GPS data that was extracted from Mr. Burgos' government-issued mobile radio. But the state's expert testified under cross-examination that she only measured degrees of latitude and the longitude. She did not include hour or minute measurements, which are intended to produce a more precise location. It's kind of like reading a clock. If I just read the hour hand, I'm going to tell you it's 9 o'clock. If I read the minute hand, I can tell you it's 9 o'clock with 15 minutes. And if I read the second hand, I can be even more precise. I can tell you it's 9:15 with 20 seconds. 9:15 and 20 seconds. But she only took latitude and longitude. And so I asked her if 1 degree of latitude equals 69 miles, and whether 1 degree of longitude equals 54.6 miles. And she said she agreed. And that was all that she took. So what does that do? Well, those are very broad measurements that place Mr. Burgos within 69 miles from the crime scene, within an area that he was assigned to patrol that morning. Slide number 15. The state also points to Grizelda's cell phones as being found in Mr. Burgos' patrol unit. But Mr. Burgos told investigators at the scene that he had picked up the cell phone. And just as Mr. Burgos handed his ID to investigator Garcia, and then later the investigators twisted it around to say, hey, you didn't tell us your full name, so you're guilty, get in the car. Same thing, they forgot that investigator Garcia had it, and then he gave it back to Mr. Burgos. And Mr. Burgos forgot that he had gotten it back because he was in shock. Several of the state's witnesses says that he looked spaced out. He looked like he was in shock. Yeah, because he had just witnessed a horrible crime. Maybe he was going to meet with Grizelda that morning. But can you really conclude from that you killed her? That's a huge jump in logic to make. And then the puncture wound. They wanted to take the word of Corinne Stern. Corinne Stern, who had a woman on death row because she diagnosed the death of that woman's baby with suffocation or strangulation.
I'm sorry, Mr. Peña, I'm just gonna object to that as there's no evidence of anybody being on death row. And those aren't facts, not in evidence.
I believe I asked Dr. Stern about that.
I will instruct the jury that you are the triers of the fact. You will use your best effort to recall the testimony of the witnesses that have been brought here and whose testimony has been admitted into evidence. Do your best to recall that. Remember that I instruct you that whatever it is that the lawyers tell you was the evidence is not the evidence unless in fact you've heard it actually here come from the evidence. So you use your best recollection to do the same. Thank you.
Dr. Stern also claimed that she's board certified and she's not. She came back and muddied up the water some more, and that's the type of witness that she is. But they wanted to disregard the emergency care clinic, which diagnosed the puncture wound as an insect bite. They wanted to disregard Dr. Antonio Rodriguez, a pediatrician who saw the child 3 times, and each time diagnosed the wound as an insect bite and prescribed treatment for the insect bite. And the state wanted to disregard the medical records from doctor's hospital, which also show that the diagnosis was that it was an insect bite. And then there was a testimony of Adriana Flores, who also testified that Dominic was already sick the night before Grizelda met with Ronald at Winfield Park. So above all, ladies and gentlemen, remember to rely on logic, reason, and cool reflection, and set aside the lynch mentality that the state wants you to go into the jury room and deliberate with. It has no place in there. Thank you.
You have 5 minutes left. Or were you done?
Ladies and gentlemen, we do not promote a lynch mob mentality. Everything that we brought you, all of the evidence, the physical evidence, the direct evidence, the forensic evidence, the circumstantial evidence, the medical evidence. It's all credible. It's all consistent. And it's all corroborated. You make your decision individually, collectively. And I agree with Mr. Peña. This is a serious matter. This is a serious matter. But when you go in there, let them guide you. Let Grizelda and Dominic guide you. So that you can have clarity. And that you could be able to be confident. And I guarantee you that when you take all of the evidence, all of the physical evidence, everything that we've brought you over these last 7 days, that you'll be able to go home tonight and have a clear conscience that you did your job, that you weighed all the evidence, and most importantly, that you brought justice. That you brought justice to baby Dominic and to Grizelda. Thank you.
Thank you, Ms. Arniz. Peña. Ladies and gentlemen of the jury, I'm now about to send you into the jury room, which will become your jury deliberation room. Will you follow the instructions that I've given you in the charge and start deliberating? Mr. Rubio will have the four alternates step out to another room. You will not be in the same deliberation room. You will be in another room, waiting to see if, in fact, your services will be needed. Thank you.
Okay, we come to an issue here. Do I stop this stream and start a new one for Jury Watch until the jury either comes back or they are excused for the night? Or do I keep it running here? Opinions, anyone? It's about all I can think of to do at this point is to continue on with the video from the continue with the video from yesterday because that was so extremely powerful. So I suppose we can start it again tomorrow. I don't want to stop tonight until the jury is excused because at any time the I understand that. Maybe let's see. I don't know. I know how to message Indiana, but I don't know how to message you where the wind blows. So I was thinking if I stopped and it looked like the jury was coming back, I could send out messages. You could leave a comment on the video with like a link for Facebook or something, and I could send a message there. Yeah. So, it could be that they might reach a verdict tonight, but they won't announce the verdict until tomorrow because some people might be off for dinner and so forth, and they might, want to give them an hour or so to get back, and they decide that it's just do it in the morning. So I'm not quite sure what. Um, um, or where the wind blows, you could email me contact information, and I could message you. I'm laurendellin@gmail.com. So if you want to do that, then I can, if it looks like we get a verdict tonight, I can let people know. And if you don't see it, you don't see it. But okay, if notification will do it, okay. Well, then we'll end this, and I'm going to leave the stream running on my computer. So if anything happens, I'll know right away, and I can fire up the stream again. So, okay, well, you get some sleep where the wind blows, and you too, Indiana, because it's the middle of the night for you. So, let's do it. All right, we'll hopefully see you back soon for a verdict. So, good night. Bye bye.